code now.
Yeah. All right, we're going to come back to order in the Blockchain Task Force for our second day. I'd like to recognize that Representative Yin has joined us from the country of Canada, our great northern neighbors. Welcome. Thank you for being here, Representative Yin.
Thank you, Mr. Chairman.
We're going to start off today. We're going to mess around a little bit with our schedule. Yesterday, we talked about the ULC a small amount. We have one of our commissioners from the ULC here today, and that's been kind of a little bit of tug of war with the state of Wyoming recently and the ULC in regards to some of their model language. And fortunately, that's starting to bear fruit in regards to those conversations between the Blockchain Task Force and the ULC in regards to their model language is being reworked based on the premise of some of the bills that the state of Wyoming has passed. And both Chairman Rothfuss and I have been invited to participate in the ULC's upcoming meetings in regards to their model language and digital assets as observers. And I think we're going to be both taking that opportunity up this fall to participate and hopefully help move the ULC forward with language that does protect states' rights and protects what Wyoming has done. And hopefully, there is a lot of smart cats in that room. So hopefully, we can take away something that we can bring back to the state of Wyoming. With that, I'd like to recognize Mr. Wentland and ask you to join us, please, sir. And you just got to, for the record, state your name, who you're with.
Sure. I'm Tony Wentland. I'm one of 3 Uniform Law Commission members for the state of Wyoming. The other 2 members are Phil Nicholas, who many of you, all of you may know, and Justice Keith Couts. I think I've been doing this for about 6 years. We're appointed by the governor. I think we're reappointed or newly appointed every 4 years, I believe. I think our funding is through the governor's budget, and that funding pays an annual dues payment to ULC, and then the annual meetings are mandatory for at least 2 of us. You can get a pass every 3 years. We try to have 1 or 2 of us go every year. We need to, because there's, they vote on model acts and things. This last year, just in July, all 3 of us went to Anchorage. There were no acts about this subject that were taken up, but there is ongoing discussion, and I can just sort of give you a little quick recap. Senator Rothfuss and the chair are sort of aware of the back and forth over the past year with ULC. The Uniform Law Commission is the group that works in conjunction with the ABA to draft model acts that state legislatures often use, at least as a framework to create laws. And their flagship product is the Uniform Commercial Code. That code, all of its articles are the product of their work over a period of probably 100 years now. It's a good set of legislation. It furthers what is their stated primary goal, which is that states on their own pass legislation that regulates subjects in a uniform enough way that it effectively preempts the federal government from federalizing legislation on those subjects. That's a good goal, and Wyoming has always backed that, and it's a big reason I believe we've always participated actively in the ULC. Having said that, I can tell you, your 3 commissioners, we view our role attending the ULC as Wyoming first. We try to take our cues from what we see the legislature and the governor doing. We're certainly open to your input and want to further the goals of the state. If the ULC puts something together that we think just doesn't fly or won't work for us or would cost too much or is in a subject area that they shouldn't be messing around in, we vote no. We did that a couple times 2 meetings ago on some model acts they came out with that we just felt were over the top. There was one we were the lone no vote on, which is fine. But I wanted you to know that too. The 3 of us want to further the state of Wyoming's interest first as we participate in their process. On this subject, initially when Wyoming passed the legislation, it passed 2 sessions ago, I believe. The ULC sort of was caught off guard. They had done a model act similar to that for digital assets, and they had gone a different direction, particularly with the issue of how you obtain a possessory interest to perfect a security interest in personal property, which I think is sort of the key back and forth issue with them lately, although I can tell it's one of what will be many. Their concern there is if Wyoming goes off in one way and all or 48 or 49 states are the other way because they've used model legislation, that could disrupt the idea of keeping this as a state legislative, non-federal area. The flip side, however, from Wyoming has been, what are you waiting around for? These are important. This is going to change anyway. And I think there was some back and forth then. Another thing that happened when Wyoming moved forward, the state of Nevada started showing interest. And then that sort of set off a reaction at the Uniform Law Commission Executive Committee leadership group about what's happening. We thought we decided how this was going to be. By the time that got to us, at that time it was mostly me, or I think Justice Couts participated in those decisions a little, or discussions a little. We told them, we said, look, Wyoming may do what Wyoming does. You need to recognize that. Maybe you were too conservative. Think about that. That ultimately led to this spring. I was able to talk to the president of the ULC at that time. There's a new president now. But it was Anita Ramasastry from Seattle. She convinced the executive council of ULC to convene a new round of kind of a study committee about this issue in the UCC. And I asked her then if we could get one or two of our folks from this committee on that group as observers, which means they're full participating members, except they won't vote as a commission member would. And that's done. And so Senator Rothfuss and Senator Lindholm will go to Denver. They can fully participate. And I think, to sum it all up, my hope is you continue to interact with those people. The UCC is their flagship. You'll meet people at that meeting who have 30, 40, 50 years experience drafting UCC provisions. They know how it works. They've watched it be adopted. They've watched it be updated. There's a lot of knowledge there that you can draw on for whatever you're doing. I think they need to hear from you. They're also sort of really, they love what they have, and maybe they're not as open to changing it as they might need to be. We want to support you as three commissioners in that process. We encourage you to communicate with them whether you agree with them or not. That's my real goal, and I think Anita ultimately agreed with that, is that we need everybody talking as you guys, as this committee decides what to do with this subject. So that's what your three commissioners are going to try to help you do with this. I can tell you none of the three of us are really very knowledgeable about this subject. I think I know the UCC some days in my practice, but educating us a little bit, or if there's one of us you'd like to have help you interact with them, tell us and we'll do that. We'll pick somebody and we'll do it. It probably will be either Bill Nicholas or me. So that's pretty much what I have to tell you about that whole process this morning.
And I would also like to note, committee, one of the aspects that really was kind of or at least put it on everyone's radar and kind of a holy smokes kind of moment. Senator Nethercott had her legislation over in the Senate, Senate File 125, that was the essential bone of contention. Way to go, Senator Nethercott. And the ULC actually reached out to the state Senate and sent a letter to every state senator saying, hey, essentially kill the bill because we've got this. And so that kind of started, I think we're all a little bit pugilistic at times, and some more than others. And so that's kind of where things really kicked off. But I would note that it was our own commissioners that, we sent letters back and forth, but the reality of that situation, it was your work and Commissioner Phil Nicholas's work in that regard of reaching out to the ULC and saying, we got their backs. if they're going to do this, they've got our support. And that was really crux in that situation. So big kudos to you, especially on setting up the opportunity for Senator Rothfuss and myself to be able to participate. I might try to proxy someone in every once in a while, just because we have a wealth of information on the task force that is truly handy. And the reality of the situation is, I am a hillbilly out of Northeast Wyoming, so there are times when I am not appropriate for that conversation. It's under another Ms. Long.
Mr. Chairman, thank you. I do think it is important, despite the history of the back and forth, to lay out that no other state has enacted the Uniform Law Commission's proposed bill, because those of us in the industry have been working in every state to let the local legislators know that it's wrong. It would have been a disaster, in my humble opinion, for that to have gone through, because these are inherently bearer assets. This is a really important point. Leaving aside the debate, the substance of it is these digital assets are inherently bearer assets, and by forcing them into an indirect ownership regime where you only get super negotiability if you own them through a third party, it made no sense. So all of the histrionics are unfortunate, but the substance is that the Uniform Law Commission got it wrong. And Wyoming has it right. And the fact that other states like Nevada started to come up and say, we actually think Wyoming got it right. I applaud the Uniform Law Commission for reopening this whole discussion, because it needed to be. And I don't know the history of how it got to that point, but it was pretty clear they didn't have enough interaction with industry folks who were advising them that that was not the right direction to go. So thank you this is great news to me. I didn't know that we actually have additional observers coming into the Denver meeting and can hopefully help them understand why that original approach, which thank goodness has not been enacted in any other states, is not the right approach. And hopefully they will agree that the direction that Wyoming took is actually, once they understand it, the better direction, because really these assets don't need to be owned indirectly.
Commissioner.
I would just say, sometimes, I mean, my observation, it's only 6 years worth of service on this group, and it's been interesting to kind of go to these meetings and watch their culture. They draft these model acts through committees. The committees get stakeholder input. Sometimes that stakeholder input isn't everybody who should be there. I mean, usually it is. They're usually quite good at that. Sometimes they just miss it. Sometimes they're too progressive or too conservative about a particular subject because it's just the nature of that committee that's been appointed to draft. I don't know. This I think clearly was one that needed to be revisited, and I think the executive committee saw that. I mean, it was good fallout from the exchange of those letters, and I was also pleased. I think the president's responses to your letters were conciliatory. They said, "Well, we want to hear from you." That was what I wanted to see from them, and so I was pleased that they handled it that way. I mean, at the end of the day, the truth is they know you're the legislature here and they're just a group, and they need to help maintain a balance back and forth too, so it's valuable to both sides. There are some people in those groups or in the entire commission who really do know the UCC, and I guess from my perspective, what I would urge you to do, whether you agree with them or not, go mine. I can even help identify some of those. One of them is the chairman of this committee. Those people are valuable to you just in terms of trying to figure out how you will ultimately decide to handle this. There's a lot of knowledge there and experience. The other thing you'll find about the ULC is they have a very active, sharp, funded legislative lobbying arm, because they really don't matter unless the products that we put out of the commission as model acts get used by states. And so it's really ultimately in their interest to put something out on this that works. This is one where they're going to have to retool it some or make a hard decision and just decide not to. But we get a lot of pressure to bring everything that gets approved, whether we voted yes or no on it as Wyoming's vote, back to you and push you to adopt it. And this group of 3 commissioners, we don't really view it that way. We're fairly skeptical on just we should tell you to adopt everything they come up with, because there's a fair amount of it right now that we can tell isn't where the state wants to go. So we're sort of in the middle of all that. I mean, if you see something they have that you want to know about, they're very good as a resource of getting you information. I can get you all the background. I can get you experts. I can make like one phone call, and that ULC office in Chicago is very responsive. And so if you want some background on how they got to where they are, I can make a call and ask about that too. That might help you prepare to go perform this observer function at this new meeting where they reconsider the whole thing.
Yeah, no, I think that would be great. And one of those aspects is kind of that I think probably the reason why the ULC drafted their legislation in such a manner is because, frankly, it's such a new sector that nobody in that sector knew that the ULC probably was even a thing and that they should be reaching out to them. Or the fact of the matter is probably a very small subset that actually knew it was happening. So
also, excuse me, I didn't
go ahead,
interrupt
Commissioner.
you. I think there were also there was stakeholder pressure to maintain the intermediary status.
Exactly.
And I think they won out in the debate the first time around. That's my sense of looking back through some of the minutes, and I mean, what little of that I've been able to do. But I think that's the interaction this time is this side of the argument going to be presented more strongly,
Right,
more accurately, in a more compelling way or not? I don't know.
Ms. Long, please plan on being a proxy because we're going down there with a.
Thank you, Mr. Chairman. I actually already had decided to go sit in the room and help. I know the Wyoming Banking Division has also been invited to be observer. So this is fantastic news. This is all about a substantive debate. I'm very glad to hear your perspective that faction that was pushing for intermediaries, which I understand why they would want to default to that. There's a great legal structure set up for that. That the securities industry has operated in. And of course, the securities industry would love to get a hold of this industry and control it. But whether that happened or not in the ULC process, the result was the same, which is that they were going to force everybody to use intermediaries, which that's what we're reacting to is the substance of it. It's not the process, it's the substance of getting that fixed. And I think what we've done, I think we got it right. It's important for you to know as well. We had an enormous advisory group helping us. We had some incredible UCC experts. Milbank helped us. Sullivan and Cromwell helped us. This wasn't just, I think their perception is little Wyoming went rogue. And in fact, actually, we had law professors from Columbia, law professors from Cardozo who are UCC experts. And they reviewed what we did, and they didn't all agree with it, but it's funny. Perkins Coie gave us a 43-page memo on UCC issues relating to digital assets, where the nature of digital assets was going to clash with the UCC. So this is an evolving area for sure, and hopefully you take some comfort in knowing that we literally went months and had incredible depth on the work that we did. It wasn't just us going rogue.
Well, and I view my position as an intermediary. I'm not on your committee. I'm not on a drafting committee of the ULC. I'm one of Wyoming's commissioners, the ULC. At the end of the day, if they change it before we go to that annual meeting, we're going to want to know from somebody in the legislature how they view whatever they've come up with this time, so we know how to vote. Our loyalty is to you first. I mean, if it isn't, we might as well stop funding our participation in ULC, at least the way I view it. I'm sure that's how Phil and Justice Couts view it.
And to be honest, thank God for that, because I don't want to fight with Tony Wentland or Phil Nicholas. Been down that road with Phil, zero fun. Zero good times. You're right.
It's fascinating to me. I'm with Phil for a change. That's been kind of fun for both of us, actually.
I'm not going to lie, it shocked me last session when he said, I'm riding for the brand, what do you guys need me to do? And I was like, oh, thank God.
Well, and he's into this and enjoys it too. So
Any other questions for Commissioner? Go ahead, Mr. Co-Chairman.
Just one general question for how the ULC proceeds on these. To me, there's a difference between creating policy and making policy decisions, which theoretically is the role and responsibility of the elected officials, versus trying to forge uniform laws where you make sure that there's cohesion. And obviously, we need that in the commercial code. We'd have a train wreck if we didn't have a uniform commercial code. But how does the ULC decide when it should get involved? And I'm saying that because on this one, it seems like it was a wide open playing field where there really wasn't a lot of policy in place yet. The decisions hadn't been made, and that innovation engine that is state legislatures around the country was beginning to address this problem. Was there a discussion about, all right, what's the timing on when the ULC should be observing, picking, and then trying to create some uniformity? Or how did that conversation play
well, I can tell you
Commissioner?
how their process works to identify subjects or existing acts to address. There's an executive committee at the ULC, which is a certain number of commissioners who are president, vice president. They are the ultimate decision makers based upon recommendations from an issues committee about what to take up. The issues committee, each year we get a email that says, here's 20 areas that we think may be of interest, to form a committee to decide whether or not we should draft legislation, model legislation to recommend to the states. That circulates for the better part of a year in that committee and amongst the commission, and then that committee takes feedback and recommends a shorter list to the executive committee of ULC. They then usually pare that down and vote to form 5 new committees on 5 new subjects. Usually 1 or 2 of those are to revisit existing model acts because things are changing. I'm sure this came through that process normally. It didn't get treated any differently than anything else. Then there's a process to identify to form a committee. A message is sent out to all of us saying, do you want to be on a committee about that? To commit to one of their drafting committees, it's a 2 to 4 year commitment of time to work on that and to go to at least 2 meetings a year somewhere as a group, and then to go to the annual meeting and present if you proceed with a model act. Your first meeting is to decide whether you should be there at all. Then if usually the vote is, yeah, we should be, they've gotten that far, and then you proceed to start drafting model legislation. Those committees are formed of the commissioners, a reporter who is somebody supposedly very knowledgeable, to be the clerk drafter. One of the commissioners is a chairperson, and then you go through that process over and over. When you have a model act, after 2 years of those meetings, you recommend it to the commission, assuming it passes muster through their vetting administrative arm in Chicago. Then you go to an annual meeting, you sit on a podium. It's just like a legislature. It's like a fake legislature. All the delegations sit out front. You go up and you read the model act line by line, and any commissioner can get up. These sessions go on for 4, 6, 8 hours sometimes, and critique and comment and object to or make motions to change any word in the model act. You go through that once as a first reading. If you survive that, if somebody doesn't move to kill it, you go back and rework it again, and then you come back the next year and do that process again, line by line, word by word. You survive that, then there's a vote of the states whether to adopt that and recommend it to the ABA, who then has to approve it so it could be recommended to the states. So their process it's a very thorough process, and the people on those committees are picked both to give some diversity of political view, I think, and for their expertise. And I'm on a committee right now that's drafting model legislation about what happens to funds that are raised through crowdfunding, and then the purpose of the appeal for the crowdfunding goes away and there's money left over. And I'm in year 4 of that. And we will read a final model act next year in Madison, Wisconsin. It'll be approved. And that's my first time going through the whole never-ending process. But compared to the way you have to handle things in a short session, relatively speaking, this is like the opposite of that. This is like the slowest, most nitpicky. I mean, you'll be in those annual meetings and you'll end up with, there's one lady from Alaska who always comes, who's this brilliant woman, but she will nitpick 2 words for an hour. Just beat on people like, well, that doesn't make any sense. And I think that's part of why their product has tended to be pretty solid. Lately, I think they run out of things to do and they venture off into more social areas and things like that. And that's where our commission members tend to clash if they go off on a bender on family law or something like that. Well, I don't know how well you all know Justice Couts, but I mean, he spent years as a district judge. He's lived all of that 4 million times. You know, when they have some crazy idea about something like that, he, you know, it's like, we're voting no on that. That'll never fly in Wyoming. Nobody, you know. So that's that side of our interaction there now. I mean, we try to minimize that. We try to convince them otherwise. We try to go to the mic and say, hey, this is crazy. Sometimes we win, sometimes we lose. But so it's sort of, I sort of get to do what you do, but it's not the efficient, time-critical process you have. It's this slow, careful. And so when they're done and it passes, they all feel like they've done it correctly. And so when somebody else comes out and says, hey, we're not doing that, you know, their initial reaction is, well, how can that be? We just spent 4 years beating our way through that very carefully with everybody in this room nitpicking it. It doesn't mean, though, that they always get it right still. Sometimes the times just outrun what they're working on. And I think that may be the case here a little bit.
I think along that point, I think that's I mean, hearing all of that, I'm familiar with the ULC, more familiar than when before I was in the legislature. I had no idea that the organization even existed. And that should be a pretty solid note, I think, for industry. If industry wants to see what Wyoming has done, some of those situations codified across U.S. states, then definitely reach out to your state commissioners. I will not be advocating for a complete adoption of Wyoming's laws by the ULC because I want all of the businesses. And
well, and this is This is an interesting situation. I don't know. I've told Representative Western. This shows you how old I'm getting, but I remember way back when Tom Long and Kathy Carpin sort of spearheaded the limited liability company approach. And at that time, the IRS did not recognize LLCs as partnerships for tax purposes, and the only other state in the hunt was Florida. And Wyoming went out on its own and did that and pushed through what turned out to be a very good law. And that was an instance where the ULC actually had to play catch up because then the IRS did recognize them and then everything changed. And so this is either like this or this is something else. But this is not the first time we've sort of been in this situation in the last 40 years, from what I can tell.
any further questions?
Mr. Chairman,
Oh, go ahead, Ms. Long.
thank you. Just to wrap up, I concur with your sentiment, which is the reason why a lot of the folks sitting behind you here in this room are here because Wyoming passed SF 125, thanks to Senator Nethercott. And based on what I see, this is going to be a huge shot in the arm to economic development for Wyoming. And I'm with Representative Lindholm. I'm in the sense that we kind of don't want other states to copy it. And when Missouri introduced our bill word for word, it was kind of hard to see, honestly, for those of us who wanted to be sure we kept our lead. But on the flip side, I really do think that we got it mostly right. And hopefully the Uniform Law Commission will agree, and we'll see what comes out. But the lead that we have is actually this wasn't for naught. There's a significant economic development momentum building in Wyoming because of what we've done. So good on the legislature for doing it. Thank you.
Any further questions for the commissioner? No. Seeing none, thank you very much, sir. I'm going to open up public comment in regards to the ULC. If anybody would like to testify in regards to ULC and the upcoming action that's going to be taken by the ULC. Seeing none. All right. We're going to keep on rolling. Committee, are there any other thoughts on the ULC aspect? No? Okay. We're going to go into the Wyoming Money Transmitters Act, and we're going to kick that off with the Division of Banking. Commissioner Forkner, you have a presentation, I believe.
So thank you, Mr. Chairman. Albert Forkner, Banking Commissioner. Besides banking, the SPDIs, trust companies, other thing that's within our shop is our non-depository consumer finance, consumer protection side. And the companies makes up about 50% of our workload, and that includes the Money Transmitter Act. And so if I might, Mr. Chairman, had some remarks here that I'd like to go through, and then if I can get through that, and then at the end, take any questions that you might have. And then I may at times reference some of the information. These are a few of the documents that were sent and are actually up on the website, but I wanted to have hard copies available for you in case we do reference specific information. There's actually quite a bit there in this space. So in 2002, Wyoming was one of only 5 states that did not regulate money transmission activities, which includes reviewing for compliance with BSA, Bank Secrecy Act, anti-money laundering, so BSA AML laws. After the 9/11 terrorist attacks, the movement of money for terrorism financing was in the spotlight. States that did not have a program for licensing and reviewing such were looked upon negatively. The money transmitter industry approached the Division of Banking about putting in place common sense legislation together, and they supported the passage of a model act that had been developed for the regulation of this industry. The bill, sponsored by Senator Hawks and Representative Law at the time, was not a controversial bill, and the act was passed overwhelmingly in 2003. The Division of Banking initially licensed 23 companies under the newly enrolled act. The number of licensed entities has steadily increased, and we currently have 99 licensed entities operating under the Act. And that information and the history of that is actually the first document in your bound packet there. It is important to note that the Money Transmitter Act also covers not only transmission activities, but also stored value products. The growth in the number of licenses has been due to the expansion of services and methods for transmitting funds now available that did not exist in 2003. These include electronic bill pay services, person-to-person transfers through mobile devices, think Venmo, third-party payment providers for goods and services, that would be PayPal, for example, and stored value gift card kiosk providers. In 2018, an exemption was put into the Money Transmitter Act for, quote, buying, selling, issuing, or taking custody of payments, instruments, or stored value in the form of virtual currency, or receiving virtual currency for transmission to a location within or outside the United States by any means. In essence, virtual currency transactions were expressly exempted from the Money Transmitter Act. Virtual currency companies in Wyoming now only need to be licensed as a money transmitter if they conduct actual money transmission activities in fiat currency. Transactions where the company accepts fiat currency for the purpose of consumer acquiring virtual currency through the exchange does not require licensure, so long as the company does not also engage in regulated money transmission activities. In that scenario, think of your brokerage account. We do not regulate and require licensing of broker dealers under the Money Transmitter Act. We have information sharing agreements in place with FinCEN, Financial Crimes and Enforcement Network, and the regulation of entities operating in this industry is a coordinated effort between the states and federal agencies. State examination findings are shared on a quarterly basis with FinCEN, who is the enforcement authority for the BSA AML requirements, so that they can then follow up on any BSA AML issues that are identified. Most money transmission examinations are conducted through a multi-state examination process, and data mining of transactions conducted with Wyoming residents is completed by our office. No other state would review transactions conducted with Wyoming residents if we were no longer to regulate this industry in Wyoming. Additionally, with the repeal of the Money Transmitter Act, Wyoming runs the risk of yielding its regulatory authority in this space to the federal government in the form of a preemptive federal money transmitter charter option. We also believe that this would put Wyoming potentially to be viewed negatively by federal agencies, and especially in the work that's being done in the virtual currency and blockchain space potentially. Should Wyoming Money Transmitter Act be repealed, the state will lose its ability to guide regulatory oversight in the money services business sector. Given that, I would like to highlight what the Division of Banking has done in the money transmission examination space. The division initiated joint examinations with other states, maximizing resources and minimizing disruptions to the industry, and this has been supported by the industry. The Division of Banking created the first uniform work program for all states to regulate the industry in the same standard. This program is now utilized by a majority of states across the country that conduct examinations, also supported by the industry. The Division of Banking created the Uniform Examination Rating System that is now implemented and utilized by a majority of states in the country when assessing the safety and soundness and risks of licensed companies. Wyoming is one of 24 states in the country now participating in a working group to fast track licensing for entrants into the market that are operating in multiple states. And Wyoming is represented on the executive committee of the board of directors of the Money Transmitter Regulatory Association. During my time as chairman of CSBS, the Conference of State Bank Supervisors, Wyoming helped establish a FinTech Industry Advisory Panel to work in concert with the CSBS and MTRA so regulators and industry can develop more efficient and practical regulations. Repealing of the act would only mean that business activities conducted with Wyoming residents would be unregulated. Companies located in Wyoming who engage with money transmission with consumers in other states would still have to abide by the laws and regulations of those states. An absence of regulation would also not necessarily attract money transmission companies to relocate to Wyoming for this very fact. Next, I would like to just highlight a couple excerpts from the 2016 Financial Action Task Force, or FATF, Mutual Evaluation Report on the status of U.S. anti-money laundering, combating finance of terrorism measures, where state supervision of money service businesses was found to be generally favorable and noted as contributing to the effectiveness of the U.S. system. And the following are two excerpts I'd like to read. There are generally good licensing, registration, and other controls for MSBs, which take into account the fitness and propriety of individuals. Money transmitters are licensed in 47 of the 50 states except Montana, New Mexico, and South Carolina, as well as DC, Puerto Rico, and the U.S. Virgin Islands. And there seems to be a strong system for background and fitness and propriety checks of persons controlling them. There was a footnote to that report that reads, since the date of on-site, authorities reported that MSBs in New Mexico and South Carolina are now covered under licensing regimes as per the legislative amendments in those states. There is good coordination among the states through the mechanisms of the Money Transmitter Regulatory Association, the nationwide multi-state licensing system, and the multi-state MSB examination task force. Apart from the state requirement to license, there's also a federal requirement for money transmitters to register with FinCEN, which must be renewed every 2 years, and to update registration information in certain circumstances. Then the report goes on to state, during the on-site, the assessors identified lack of licensing of MSBs in 3 states, Montana, New Mexico, South Carolina. Then they include the same footnote that I just mentioned. The MSBs in New Mexico and South Carolina are now covered under licensing regime. With the potential to create vulnerabilities, particularly in New Mexico, in relation to the southwest border. State authorities also confirmed that this loophole might have been abused for illicit purposes. Since the on-site, there's only one state now left without a licensing regime, and that's Montana. So a couple thoughts on the benefits of Wyoming maintaining the Money Transmitter Act. and then some potential negative impacts that could affect Wyoming citizens. Consumer funds are protected when they hand over to licensees for transmission or to be held in stored value until they are used. And some of those protections include surety bonding, by ensuring that Wyoming residents' funds are covered by an insured vehicle. Permissible investments, this ensures licensed companies maintain adequate liquid assets to cover or reimburse all outstanding consumer obligations free from creditors, separate from a company's operating capital in the event that a licensee were to fail or close. And then the licensing examination process, by ensuring companies are licensed to operate and do so in a safe and sound manner, giving confidence to Wyoming consumers their funds are trusted with a reputable company. So should the act be repealed, a couple negative consequences could be consumers lose the protection that we just discussed. There's no point of contact to assist Wyoming consumers in seeking recourse if funds do not reach intended recipients or stored value accounts do not work as agreed. Consumers would have to find their own remedies and or hire independent counsel for legal recourse if the need arises. Wyoming works closely with other states and federal regulators through information sharing agreements and MOUs to share examination findings and identify potentially bad actors and or financial risks to consumers. And then finally, listening to yesterday's comments, it was very similar to some of the concerns that we have in relation to, I believe it was Mr. Cornish's testimony regarding the need for law enforcement involvement in digital assets. That is also a need for state-level involvement in money transmission regulatory space. So with that, Mr. Chairman, I appreciate the opportunity to make those comments and stand for any questions you might have.
Questions? Senator Nethercott, go ahead.
Thank you, Mr. Co-Chair. A question about New Mexico, because I think that's probably a good illustrative example of why to do it, why not to do it. So I understand it wasn't they had no licensure requirement for a significant period of time, and then recently they have enacted a licensure requirement. How many of the money transmitters within the state of New Mexico had to shut down as a result of not being able to qualify for the licensure?
Commissioner.
Mr. Chairman, Senator, I don't have that information. We could reach out to the New Mexico Regulatory Authority to see if they maintain that information, but I don't have that.
Mr. Co-Chair? I do think that's really important to gather some information and data on the effects on New Mexico, only to gain an understanding of how the failure to have licensure opens the door for abuses and what that actually looks like. Mm-hmm. So I think that's important. That's it for now, Mr. Co-Chair.
Yeah, go ahead, Mr.
Chairman. I have a response. Yeah, Joel Mulberry, Deputy Commissioner in the Wyoming Division of Banking. I'm not sure what is happening. We can get that information from Mexico, but I was on staff when we passed the Money Transmitter Act initially in Wyoming, and so before we licensed and had this been, and we were in the same situation as New Mexico. When we put our act on in 2002, there was nobody of the initial 23 licenses. Nobody had to shut down as the result of the new act that we put on in Wyoming. Everybody was able to get licensed that was operating in Wyoming at that time.
Mr. Co-Chairman.
Yeah, Mr. Chairman, kind of along the same lines, it would be beneficial to understand what changed in New Mexico with the addition of the law. Is it more difficult? Is it more costly to adhere to the law than it was prior to it? Are we finding that consumers are better protected and that there are real implications to having the Money Transmitter Act in place, where we're then capable of concluding that without it in place, bad things were happening? I mean, it would be nice to see an actual before and after comparison in cases where we have that capacity, so we can better understand what the real implications are. And at the same time, if we had some real understanding of how Montana was being adversely affected by not having it, I think that would be useful. And I don't get a sense of, well, Montana's collapsing and it's a doom and gloom state as a result of not having the Money Transmitters Act. But at the same time, that doesn't mean there isn't some modest amount of fraud. For me, what this comes down to, is it worth the additional burden? And we know that there's additional bureaucratic burden as a result of this. Are we net winning or losing? And then the third thing I would ask is there a way? Well, I'll ask this: is there any threshold level below which you don't have to file? I mean, do a small amount of money transmitting have a small amount of value you're holding? If I've got a $500 asset that technically meets everything else, but it's only $500, I assume I still have to file a full license. Is that accurate?
Mr. Chairman,
Commissioner.
that is correct. There is no threshold, and either you're licensed money transmission activity or you're not. And so, yeah, there's not a de minimis at all.
Is there any state that does something that allows a de minimis total amount? Has there been any discussion of that?
Mr. Chairman, Senator, no, not that I know of. Now we have, and I can talk about a few initiatives. I will say that again that this is a space. I mean, if we want to talk about what the cost of consumer protection is, I think that's a much broader discussion than just money transmission. I mean, we have 4 other acts, which are consumer protection acts. That really becomes a broad discussion, I think, for the legislature to consider. What is the cost of supervision in those various areas? I would say, and maybe I'll ask the question, because I apologize I wasn't able to make the first meeting this year of the task force. Have you heard from, or has anyone heard of a burden, a cost of supervision in the money transmission space that we're not aware of? And the reason I say that is we have not received any complaints. We have a $1,500 application fee and a very small annual renewal fee, and then we have a number of initiatives underway to streamline and make it more seamless across the 50 states, less Montana, and the territories, because we understand that's the balance between the state and federal oversight in a certain area. Would you rather have the state supervising and protecting its consumers, or driven by a federal policy? I'm a firm believer that we have a better understanding of Wyoming consumers than anyone in DC does. And so, anyway, so I have that question. If you've heard about that, we'd sure like to talk about. And then,
Mr. Chairman?
Yeah, go ahead, Mr.
To
Co-Chairman.
just address that point, I don't think it's the death by 1,000 cuts concept more than that this is an onerous burden in the state of Wyoming. If all I were doing were practicing, and my entire business is being a money transmitter, and I had this great plan for it, a $1,500 application supervision is fine. It's just the fact that if I want to operate in 49 other states as a money transmitter, how do I go about doing that? Can I apply for one license in Wyoming and have that work for the entirety of the country? Am I then done?
Commissioner.
Mr. Chairman, so that's a good question. No, not exactly. But again, that comes back to the independent state sovereign issue. And is it a state consumer protection, or is it a federal consumer protection issue? I would like to highlight, if I would, it might demonstrate what we're doing. And so let me see. I apologize. I didn't get master pages on numbers on this. So the second section, there's a one-page. It's called CSBS announces FinTech Industry Advisory Panel. And so that's after the kind of the PowerPoint presentation, right in the middle. On the back side of that page, these are the companies that are involved in our industry advisory panel. And they're the ones who came up with, we sat down, had a number of meetings over the last 2 years to say, okay, where are the pain points? What is difficult in a multi-state environment licensing? And the biggest pain point is yes, going to 50 states, 49 states, and then I guess the territories to get money transmission licenses. And while I would say probably 80% uniform across the country, there's enough of it to where it's painful and costly for a company to get licensed in each one. So these players, and you can see that these companies are very well known. You've got Google Payments, you've got PayPal, Green Dot Corp, Alipay, and so these are some of the biggest players not only in this country but globally in the money transmission space. And so,
Mr. Chairman.
Okay, the co-chairman first here.
Sorry to interrupt, but on that point, if I'm on that list, I don't care about this regulation. Honestly, I'm surprised they showed up at the workshop to fix it, because I can afford to hire 5 attorneys and 5 accountants to make sure I'm complying with the banking division. I think more of the sensitivity here is if you've got a startup and you don't want to spend 1,500 times 50 plus the legal fees. Plus, honestly, you don't even know if you're complying at that point because you're no good at this and you don't know what your obligations are. It's the 50 doses of bureaucracy where you're hopeful at the end of it you're complying, because if you're not complying, bad things are going to happen. Where we're trying to, I think, at least I am, determine whether that's actually necessary, whether Wyoming needs to engage in that regulation because there's a sufficient enough consumer protection to justify it. I just don't think Microsoft or PayPal cares if they have to do it 50 times. They shouldn't.
Mr. Chairman,
Mr. Commissioner, go ahead.
Senator, so I would respectfully disagree based on our discussions with them. The one, oh, absolutely. Yeah. Now, is it the financial impact? Can they absorb it more so than this startup? Absolutely. That's not really the issue. It's really having a seamless process, understanding that this is not going to be an unregulated environment. So at some point, you get enough states and you put a hole in the country. FinCEN has opined that there will be federal legislation. In fact, right now, the state of New York has a lawsuit. Conference of State Bank Supervisors has a lawsuit against the Office of the Comptroller of the Currency for what we feel to be an overreach in their authority for their fintech charter option at the federal level. It's not going through the legislative process. By rule, they're saying we have the authority to charter and have a nationwide single federal money transmitter charter. That would then take the supervision of Wyoming's money transmission industry and send it to D.C. Like I said, personally, I have a problem with that. I believe that our legislative body, and in the last couple of years, has demonstrated nimbleness. Our policy in the state of Wyoming to not supervise through enforcement has worked well, and I think the state of Wyoming and the Wyoming citizens then are yielding that over to the federal agencies. It's not like we're going to help anyone out by not regulating it in Wyoming. It'll just be the Wyoming citizens. Microsoft, any company, any startup that wants to operate in more than one state will still have to go through the process. But what I will say is, part of that, and recognizing that we can't just sit back and say, well, it's a states' rights issue, you do what we say, and I don't care what the other states do or how painful that might be. So we've started a few initiatives, and one of them I mentioned was that it's been growing organically. It started actually out of the state of Washington, and we were, I think, number 10 or 11 to join the group, and we're up to 24 or 5 now, of doing a single application process along multiple states. And so the idea was it's a phase 1 and phase 2 process. Phase 1 are the bigger states where these states are these companies are domiciled. I think Washington, California, Illinois, those ones. The idea is you apply with them once, and like I said, probably 80% of all the state statutes are similar. So they will review all of that, the application, and once they approve that, then the other states in which you want to participate in or do business in, go to them, and it's for the much smaller items. Is there a different bonding requirement? Is there something in the state-specific law that we need to consider? But it's in essence a fast-tracked process. Now we've done one pilot. We're just completing the second pilot, trying to decide if we need one more pilot to refine it, or have we got it down well enough. I know my money transmission examiner is involved in almost weekly calls on that to make sure and refine that process. The other part of what they're doing is we're just completed a pilot of a one company, one exam program. So think of the largest companies, PayPal's, Western Unions, whomever, they could get 10, 12, 14 examinations a year. And so you've got examiners in there regularly. One, we're trying to do more multi-state. I actually chaired a committee through CSBS that worked with this Consumer Financial Protection Bureau to coordinate examinations between the states and federal agencies. But this one company, one exam pilot is to do just that. It's to send in a multi-state team, do one examination, share the examination findings with the other states, and back in their home offices, if you will, and then look to make sure there's nothing that violated, let's say, Wyoming's laws or some other issue in those states without us having to go in there and conduct our own examination. So then we can accept that examination as our own. And the idea, again, is to reduce that burden there, but still have an examination process in place.
Yeah, follow up. Go ahead.
On that, do you currently have the statutory authority to accept that? We don't have specific enough language that says you have to do the examination.
Mr. Chairman, no, we would believe that we have the sufficient authority in place right now.
Second question, Mr. Chairman.
Go ahead.
Would statutory reciprocity laws help? Would that be something where we're more explicit on perhaps an approach to reciprocity where, for example, you have the authority to say this state meets Wyoming's standards, therefore we will accept their certification and reviews as our certification and reviews will grant reciprocity, something along those lines? Has that been discussed or
Mr. Chairman, Senator, I don't know on a true reciprocity if that works or not. And the reason I say that is because of the MOUs that are in place with FinCEN that the states have in place and the information sharing agreements. So we'd have to look in that. That might be something to contemplate to see if that actually accomplishes anything outside of what we already have the authority to do with information sharing, with accepting of examinations, with joining multi-state exams. But we can sure consider that, and I'll check to see if the industry advisory panel, if they discussed any of those issues. So.
Yeah, go ahead.
Do you have an estimate of what the 1 year cost, or I guess there's the startup cost and there's the annual cost of being a 50-state compliant money transmitter is just for compliance? Do you have a sense of that?
Mr. Chairman, Senator, I don't, but I'm almost certain that we can reach out to some of these companies and they have that because it's part of their financials, right? And so I'm sure we can get that on it depends on how broad they are, but yeah, but I can look to see what that figure is.
If you could get that, that would be appreciated. Thank you.
Absolutely.
Thank you, Mr. Chairman.
Yeah, Mr. Cole.
Mr. Chairman. Quick question. I think you mentioned that Montana is the only state that doesn't have the licensure right now. Have they, to your knowledge, have they suffered any of the repercussions, the federal preemption, anything like that?
Commissioner.
Mr. Chairman, Mr. Cole, I don't know. A couple reasons. If it's an unregulated space, you wouldn't know the activity going on in there. Is there or isn't? So, is there going to be federal preemption over one state? No, because then again, you've got the movement would be that you're going to preempt the 49 other states. You're not preempting an unregulated state. So, but to the activities that goes on there, and since it's not a regulated industry in Montana, there's just no information really available on what activities do or don't take place there.
Yep, go ahead, Representative Olson.
Thank you. I think Co-Chairman Rothfuss really hit the nail on the head. Talking about, Google may be concerned with the $1,500 application fee, but I think it certainly is the startups. That cost for the 53, it's actually 53 states because you have to add in the territories. I'm just looking online and I'm seeing it costs $175,000, over $175,000 in application fees and renewals at $135,000, which is not a lot to Google, but a lot to a startup. My question for you, Mr. Forkner, is on the bonds, the surety bonds. So the is it $1,500 for the application? But then there's a surety bond that you determine the amount of the surety bond, which is a percentage based on the net worth of the company. Is that how do you determine the surety bond, and what is the cost of the surety bond? What is the average cost of the surety bond for Wyoming registrations?
Mr. Chairman, I'll address that.
Absolutely.
In the statute, the initial surety bond is set at $10,000 for a new company coming in and getting licensed in Wyoming. I'm not sure of the cost of that. I can find out what the cost of that would be. Thereafter, it's annually. They have to adjust it based upon their volume of business in Wyoming. So once they start operating in Wyoming and they have outstanding transactions, they have to maintain, pursuant to the statute, a surety bond of 2.5 times their average daily outstandings in Wyoming, and that's just adjusted annually at the time of renewal. We look backwards at the average outstandings that they did in the previous year, and they have to adjust their bond to be 2.5 times what that average outstanding balance was.
Follow up, Mr. Chairman.
go
Yeah,
ahead.
I think that number is important for us to know because when we talk about the application fee, it's one fee. I mean, Senator Rothfuss mentioned legal fees, et cetera. It's hard to calculate that, but I think that the surety bond is actually going to be the biggest hit for that individual. I think it's $10,000 up to $500,000, and the way that I read the statute is that the commissioner, that's you, determines the amount of the surety bond necessary. And so I don't know I think it'd be helpful for the committee to know if you could figure that out. What does a $10,000 surety bond look like? But what is a $500,000 surety bond? And surely you would know what surety bonds are required. So you would be able to tell us if they're at the 10,000 and 500,000 is a big spread. So I think you'd be able to tell us if the majority of surety bonds are on the upper end of that and what that cost would be to the startup.
Mr. Chairman,
Go ahead.
yeah, we can get you that information, yes. And but it's not, we don't just randomly select the bond amount within that range. So essentially, it's 10,000 when they start, and then thereafter, it's 2.5 times their average outstanding adjusted annually to the maximum. If they're 2.5 times their average outstandings is $1 million, then they only have to get to the maximum of 500,000. But in between that range, if 2.5 times equates to a $300,000 bond, then that's the amount of the bond that they get.
Mr. Chairman,
Go ahead, Commissioner.
Apologize again if there's not page numbers. One of the in the slide deck, one of the slides shows, and it's probably, I don't know, 8 or 10 pages in. It's called the geographic footprint, and it shows you of the licensed money transmitters operating in the country, how many of them are multi-states and how many of those are, so we've got 115 companies that are operating in 20 plus states. Now, I don't know, does that mean the average is 21 or is the average 48? I don't know, but you've got 39 operating in 10 to 9 states, 109 in 2 to 9 states, and then you have 244 that are operating in just a single state. And remember that the Money Transmitter Act incorporates more than just money transmission. It's money services business. And so that small number, while I don't have exactly the makeup, my guess is those are check cashers, most likely, that are just any of the communities that we all live in. There's a couple check cashers probably there. They're usually incorporated with a pawn shop, maybe a payday lender, but that's part of falls under the act. And so within the discussion, we need to make sure it's also understood that yes, there is startup costs, absolutely, and we want to be cognizant of it, and that's why we don't just arbitrarily set some of these things, but those that are operating in the 20 plus space and a more nationwide and really in that case probably global are the ones that money is money. I get it, and it's easy to spend other people's money, but that is not the driving factor. I think we acknowledge it here. The Googles and the Microsofts and stuff are, the application fees in these states, while they wouldn't want to pay any more than they have to, they can absorb that. The startup costs or the startup entities, you don't have startups that are going nationwide on day one. They just don't have the infrastructure in place to realistically do that. What happens is they build out, and then you'll see a consolidation or an acquisition, which then usually that's how the footprint's expanded. So that kind of gives you just an idea of what this looks like in the space. And again, this really, I want to make sure that we're not just trying to protect a kingdom here. It was something that was thought out by the legislature in 2003. It's really, I think we're talking about is do we want to leave the authority with the states, or do we want to give the authority to the federal government? But it won't be a space that will go because of money transmission and the opportunity for terrorism financing, money laundering, things of that nature on a global scale. That's why AML KYC is recognized globally. We're not going to solve anything. It's whether we want to shift that from the state to the federal, and that's kind of, I think, a broader discussion.
Yep, go ahead, Senator Rothfuss.
Thank you, Mr. Chairman. So the barrier to the small startup is honestly my biggest concern at this point. And you say that things seem to have gone well. What we don't know going into the unknown unknowns is we don't know how many startups that would have done a financial technology looked at the Money Transmitter Act and said, I am not going into that space. That's brutal. I'm going to go back and work my day job. What would be the downside if we don't end up going with an entire repeal of it in the state of Wyoming? So, and maybe there are these startups in Montana that are looking at it and say, all right, there's no barrier. If you did less than $10,000 arbitrarily or $50,000 of annual business, and you just registered as a micro money transmitter, no fee, register it so that you know it exists. You can keep an eye on it. If it grows, all of a sudden they're reporting $10 million worth of transitions. That's great, but you basically just know it exists as the entirety of the registration, or maybe they file every year. We did $2,200 of business last year. Is there a downside to that? I mean, what is the risk there? Because the total dollar value is low enough that I just don't see a threat. What are your thoughts?
Mr.
Go
Chairman,
ahead, Commissioner.
Yeah, Mr. Chairman, I'll address a little bit of that. I think potentially we've addressed that with the implementation of the FinTech Sandbox last year that we're getting ready to implement. We're in the process of doing the rules and getting the application process. But that could be a case where a startup can come in and apply to operate for multiple years to see, are they going to be a viable business? And they can operate. And one of the things we could waive potentially under there is the licensing requirements, and come in and just have those initial outlays. We can let them operate potentially in the sandbox, for a period of time to determine, are they going to get big enough, to come to, some other kind of to the point like you're talking about, some kind of a de minimis threshold to exceed. It's just potentially something that is out there currently that we're working on.
Yeah, go ahead.
But on the financial sandbox is I think a wonderful resource. But I don't know if imagine you've got a coffee shop that for some reason comes up with a neat little way to hold value that technically falls under the Money Transmitter Act. And I don't know what the hell that's going to be. You've got some creative idea, but at its core, it's a coffee shop, and it's going to continue to be a coffee shop. It doesn't want to take over the financial world. It just wants to sell coffee and do it in an innovative way. The financial technology sandbox wasn't made for them. And maybe they'll do $5,000 of money transmitting over the year, every year for the next 25 years until the person finally retires. It's still going to require an entire money transmitter license, and they're just not going to do it. I mean, they're going to find out, wait, there's a law against that? Okay, I better stop before I go to jail. Is there really any threat to a de minimis money transmission as long as they register?
Go ahead, Commissioner.
Mr. Chairman, Senator. So let me, two parts that answers that question. So let me tell you about a little coffee shop. What we might have heard of, it's Starbucks. They're a little coffee shop. All they do is sell coffee. They have a stored value product. In fact, I would venture to say in this room, a majority of us have their app, and we have some money in that account stored with them. That is a closed loop system and does not require money transmission licensing. So in your scenario, and I get the broader sense of what you're asking, but that's really not a realistic scenario. That a business, an ancillary business here says, well, we're going to do something that's money transmission space, because what we would say, just like a stockbroker, consumer credit counseling services, cryptocurrency exchange that deals only with crypto, those don't require licensing anyway. And so I don't know, to your point, I can't really answer that because I'm not quite sure. We've got a scenario where it is. So now if we're just talking about what are the startup costs, again, we've got to figure out what is the scope and scale of what the entity is wanting to do. If they have national aspirations, one, they're going to have significant funding behind it. They probably would have gone to market to get, whether it's debt or equity financing, and we're talking in the multiples of millions of dollars because you want to roll out nationwide. If you're going to grow organically, then you're going to go one to one and see how that goes. Or, like I said, maybe through mergers and acquisitions, you can grow into multiple states. That's a scenario now we can try to find maybe if there's some numbers on that, what that is. But I get what you're saying. I just don't know if it actually we've ever seen something like that be a problem. Now, to the point of a startup that looks out into the space and says, wow, this is, we'd like to operate in the Rocky Mountain region. That's 5 or 6 states, and that's going to cost us this. And if they decide to not do that, and if we've not had some indication or seen some financial projections, and then get a sense for it's just too burdensome, too costly, because of the regulation, forget this, we got to separate the regulatory costs versus just the startup costs of any institution. We may not ever know that, because if again, they do their due diligence and then decided that maybe it wasn't worth it, we would have no idea of that occurring. But I get what you're asking, is there something to prohibit that? And that's, what we're trying to figure out, is to make sure that the state of Wyoming has the authority and protections in place for the citizens of Wyoming. And again, it's not driven by DC, or it's not a policy from New York or California or something. I don't think we want that personally.
Yep. Follow up. Go ahead.
But it still hasn't been an answer to the question: is there a substantial risk to a de minimis micro business and microtransmitter? And again, looking at, I totally agree. We don't want Washington D.C. telling us what to do, but I don't. This is just my intuition. Feel like if we had a $10,000 per year transmission threshold before we put in all of the bells and whistles, I don't think DC is going to say, all right, well, they're not fully regulating, so let's rain lightning and thunder down upon them.
Go ahead, Commissioner.
Mr. Chairman, sir, no, I agree with that, except for, again, I need to reach out to FinCEN and see what theirs, because these entities are still registering with FinCEN, right? FinCEN then relies on the state, very similar to the discussion that we had yesterday, whether it's the state law enforcement or the FBI gets involved. FinCEN does not have an examination force going into all of the states examining registered MSBs. That's why we have that MOU in place with them. So we do the examination, we submit the findings to FinCEN. So in this case, if we have a de minimis, is that an issue? Again, probably not much terrorism financing going through a small entity, but does that create a loophole that is uncomfortable on a more grander scale from our partners there? I don't know that, but we can sure reach out to FinCEN.
Go
ahead.
Who pays for when you're doing the annual investigation or review? If you actually dig in, I assume you bill them for it.
Yeah, Chairman, correct.
Go ahead.
And what would that cost?
Mr. Chairman, it depends on, again, the company, the scope. If we're doing more off-site work, if we have to go on-site, it depends how much records come to us. If we're a lead participant in the multi-state exam, if we're just a participating state, we probably have I guess we probably could look back and get an average of what the examinations cost in any given year. Again, it'd be red apples to green apples at least, because it might be a smaller entity last month, and then we might be in Western Union next month. And so, but we can sure look to see, is there an average cost? And I don't know if we track it granularly enough based on the size or the volume of activity, we break that out. We probably have that, a way to mine that information a little bit. We've not tracked it on an individual annualized basis.
Thank you.
Further questions for the Commissioner? Representative Yen, go ahead.
Thank you, Mr. Chairman. Commissioner, so this might be a metric that might be useful for some of the members on the task force based on what I've heard. But do you know, since every MSB also has to be registered to FinCEN, is there a higher per capita number of MSBs in Montana versus every other state that is regulated? Do you know that? Is there a number that we could be able to pull or look up, find out?
Mr. Chairman, Representative, that's a good question, actually. We'll see if that, again, we'll see if FinCEN tracks that information. I mean, again, Montana wouldn't because they don't supervise it. But let me see if there's a way to get that, or if you have it.
Mr. Chairman, I'm not aware of, because MSB is a broad category. Like in Wyoming, under our Money Transmitter Act, we're only dealing strictly with money transmitters. We don't do check cashers, the other things that are defined as MSBs. For the actual money transmitters, I'm not aware, none of the money transmitters of the 99 that are licensed with us, none of them are housed and have their home offices in Montana.
One more question, Mr. Chairman.
Yeah, go ahead, Representative Yen.
Mr. Chairman, thank you. Commissioner, so given that in the statute, both the application fee is adjustable by you, as well as the amount of surety bond after they start up business and have some amount of business that you can adjust a surety bond for. Has any business ever come to you and said, since you control this number, is there any way you could lower this number because I feel that it's too burdensome? Has that ever happened?
Yeah, go ahead,
Mr.
Commissioner.
Chairman, Representative, no, not since in the last 7 years I've been commissioner.
Thank you.
Thank you, Mr. Co-Chair. You briefly indicated the need for law enforcement investigation as it relates to some of these concerns. Do you want to expound on that, of what your needs are? You mentioned statewide.
Mr. Chairman,
Go ahead.
Senator, no, what I was saying is very similar to the discussion that was had yesterday regarding the, I think, whether the FBI would get involved on investigations of, I think it was computer crimes that we were talking about at the time. It was very thing that if left to the federal agencies, they may or may not investigate that. So it's a similar discussion. If left to, if there's a consumer harm in Wyoming left to a federal agency, would they or would they not investigate that, as opposed to right now we have a regime in place that we get a call and someone says, and we don't get a lot, but we get calls saying, like, I tried to transfer money overseas and they're saying it's not there. What do we do? And so we'll contact the company, and within 24 hours, the sender either has their money back or the transaction was processed through. And so without us, the state overlooking that, then it goes to the individual to find a resolution. But it was more about a parallel as to the discussion.
Just real quick, Commissioner, in regards to, and I think the biggest aspect here, and I know on a national stage, and this is a really weird place for me to find myself, I'm standing with the Office of the Comptroller of Currency, because they recognize that this regime is a huge hit to fintech startups. And so they've actually started, as you know, and I'm guessing you're taking a stance against this, that they've started chartering these new startups to be able to transact business across state lines because of the regime that is currently in place being restrictive. So that's kind of problematic in that regard. And so could you, touch on the Office of the Comptroller of Currencies, what they're currently doing, what that lawsuit looks like, and where your office stands on that?
Mr. Chairman, thank you. Yeah, so they haven't started. They proposed. There's not been an application dropped, and I'm guessing because of the legal uncertainty whether they ultimately have the authority. Now, my personal opinion is, even if we're successful in court, the CSBS in New York, legislation will be dropped, and that will be preemptive legislation. And so, but that was no different than the trust banks. I want to say maybe 78, roughly. They tried a similar thing, and through in essence federal rule, to offer a trust bank charter. That was opposed, saying you don't have that authority. Went to Congress, got the authority, and then they had that. They've since abandoned that model. So that, yeah, to the point of if you're a national player, absolutely. And so that then comes back to, and it's a discussion that the legislature may find like you said, an interesting situation in understanding. We don't want to stifle innovation, although I would argue, I think there's evidence to suggest and support that the states are the incubators for innovation. Most innovation comes at the state level and then is rolled out at a more national scale. We're much more nimble. So to take the analogy the same way, if you're a company, why would we really need or not be supportive of a federal special purpose depository institution charter option? It's the same discussion. Do we want that to be here in Wyoming? But I can tell you the discussions with companies that we have, they have a global footprint. It would be much easier to just go to a single federal regulator. Now, the devil you know, the devil you don't, I don't know. So is the state of Wyoming going to support sending, moving away from the state's rights in that regime and handing it over again? And so let's argue and say, let's have a federal charter option for an SPDI. I don't think, again, that's what we want to do, but it's a very similar discussion. It's the same. We're talking the same magnitude of companies that would be impacted by states versus a single federal regulator.
Mr. Co-Chair.
Yeah, go ahead, Senator.
just to put that out there, both for the committee and for the commissioner here, is there any kind of compromise that can be made as opposed to balancing those interests of providing consumer protection yet being friendly to startups?
Mr. Chairman, Senator, again, I guess it looks, we'd have to figure out what problem are we trying to solve? What problem has the industry came and said that this is burdensome? I mean, other than we recognize the multi-state licensing, but making a change in Wyoming, unless we think somehow we're going to sweep the country, and at that point we are yielding it to the federal government because there will be a federal oversight there. There's where money transmission will not go unregulated in the United States of America. So then I need to figure out, well, what are we looking for? What have we heard? Again, I'm not saying that there's not an opportunity to do that. The initiatives that we're doing that I mentioned, and in fact, the last document of your the FinTech Industry Advisory Panels, their payment subgroup suggestions on page 4 of that they actually acknowledge and recognize the need for and desire of regulation of money transmission. We're now trying to make it more seamless across the 50 states and the territories. So if there's something in there, if the de minimis we think would do that, to Deputy Commissioner Mulberry's point, I think if there's some prohibition or something that makes it difficult for a startup to even contemplating, I would say our sandbox is the right way because they won't know. That gives them 2 years, potentially 3, to test to see if they even have something that they can take to market. That's the whole point of sandbox, right? Is to see if it's viable or not. So to answer your question, if we can identify what we're wanting to compromise and what problem we're solving, then let's have that discussion. Absolutely, I am all about, and I'm on record a number of times saying that right size regulation is absolutely appropriate way to go. And if we're overburdening and when we're stifling that innovation through regulation, then it needs to be adjusted. Absolutely.
Ms. Long.
Mr. Chairman, thank you. I think it's worth noting that one of the reasons why our SPDI is so effective is exactly this burdensome issue, that the state chartered banks can actually be ported into a lot more other states than state money transmitter licenses. Costs a lot more money to charter a bank, takes a lot more time. And it's so interesting because I question whether a $1,500 bond. I mean, what's that? What kind of protection does that really provide? But
that's the fee. The bond is much higher.
Okay, but I think the state of Alabama, it is only a few $1,000s the bond, right? So it's like, why are we having this regulation? But on the flip side, part of the reason why I was initially so supportive of this was that it's a resource issue within the Wyoming Banking Division. We have a killer app in this SPDI law, and given that is portable into, we think, 42 states without having to kiss the ring in 53 states and territories, right? So the bank license is the better way to go. Granted, again, the capital requirements are a lot higher. It takes a lot longer to set it up, but we do have an answer to this issue. And the reason originally that I supported the repeal of the money transmitter law back in Jackson was the resource constraint issue. Can you talk about resource allocation within the Wyoming Banking Division? Is there a conflict that if we repealed the money transmitter law, that it would free up resources for you to focus on all these trust companies that are applying? Because, of course, there's that whole other trust opportunity for Wyoming, and then the SPDIs that are coming as well.
Mr. Chairman, Ms. Long. So to your point, yeah, that is, and then so you mentioned Alabama. I mean, that highlights there are differences among the states, and that again, it's left up to, and not dissimilar to the discussion we started the day off with, is uniform laws, model laws. What happens? In my mind, a uniform law is only uniform as long as one state passes it. Because you're never going to get more than one state to agree on something. There'll be some change, but the resource. So we have, and over the 13, 14 years that we were supervising money transmitters, we only had one money transmitter examiner. Again, because it was a slow, steady growth, and that was sufficient. We just hired a second money transmitter examiner now that we've got more companies. those examiners are trained solely on money transmission MSB supervision, and we do a little cross training on our non-depository side where a money transmitter examiner might be able to pick up and do say a pawnbroker exam or some other simple consumer finance examination. It doesn't translate. It's a completely different skill set to be on the bank side or trust company side. In fact, just 2 days ago, we hired our first trust company examiner, dedicated trust company examiner, because of that growth. So it doesn't free up a resource there. Plus, the whole idea of having the license fee and then pay for the examination fee directly is to support the cost of supervision. And I'm not even sure if actually they fully support. If we again went back and looked to see is money transmitters fee entirely cover that, I don't know. We look at it a little more broadly as non-depository supervision, but to point that it doesn't give me two more bodies immediately to then work on SPDI or trust because it's a whole different training regime.
Thanks, Mr. Chairman. Thank you,
Yeah.
Commissioner.
Yeah. And just as a kind of a side comment, or actually it would be a good question. What kind of information is your agency sending to FinCEN in regards to data collected on any Wyoming citizens? Is there any PII there? Are there Fourth Amendment concerns? Have those ever been brought up?
Mr. Chairman, we don't transmit actual data. I think that what we share with FinCEN are the findings of our exam reports. And so in there, if there's during the course of our examinations, if we identify some problems in, BSA, AML, kind of concerns, I mean, we will definitely share with them what the results of our findings were. But we're not doing total data dumps of the data, back to FinCEN, in the regular course of sharing. We only share with them the violations that we note during our examination process.
Well, and to touch on that, that's kind of an interesting aspect because yesterday we kind of shared and talked about the situation that's currently going on with rural people in regards to those are KYC violations because there's no federal recognition of 26 Windy Way up by Sundance, Wyoming. Listen, it's way out in the sticks. Is that a violation on my fault? Is that my fault? No. But now that data can be shared and is being shared with FinCEN. And so,
Mr. Chairman,
help me out.
no. And again, so some of the details, and actually, if there's any compliance officers that actually do the BSA filings and whatnot, they can talk about it, or I can get the information from my examiner. Two things: we examine BSA, AML, KYC in banks and trust companies. And I can tell you, we've never had that issue. Whether just because your address isn't recognized by the USPS, there are other mechanisms in which a bank can verify you are who you are and that you're not a terrorist.
I think we're talking apples and oranges, though, because those types of online accounts that an individual would sign up for, that's an online verification. Whereas I go to my hometown community bank and sit down with Andy Miller, who's the president, does a super good job, bank at Sundance State Bank, by the way. Throw out a plug for him. The reality of that is I'm handing over my driver's license. They know me. I grew up with those guys. They write it down. There's no verification system in place besides I know Tyler. I mean, that's how it happens. It happens right here. Whereas online, it's a very different animal.
Mr. Chairman, that is correct. But they still have the requirements, and they know you. And so, if your driver's license, again, not knowing if it puts PO box or puts your county road address on there or not, that is then recognized. That is a recognized official government ID with that address that can be utilized as part of the verification process. And so,
I don't believe PO boxes meet that height requirement in regards to KYC, though. Correct.
Mr. Chairman, yes, you're correct. And so I think if we came across that situation in the course of our examination, what our examination report says is that on this transaction number, that the company or their authorized delegate failed to obtain the necessary address. They obtained a PO box, which is in violation. And so our examination report would just kind of outline the transaction number and what the violation was. And then we share that examination. We don't transmit the actual data to FinCEN. We will share our examination report. FinCEN has the authority to investigate that directly with the companies themselves if they want to. We don't get involved in the transmission of the actual PII information. So it's very minimal. On this transaction that we reviewed, there was this violation that they only obtain the post office box, and then in the course of that, in the sharing of that with FinCEN, if they then want to follow up and get more details on that, then they use our findings to then enhance their regulation. And at that point, then they're following up directly, probably with the companies rather than through us.
And this is a complicated deal. I know you guys are really diving in deep, and I super appreciate it. So say a money transmission happens in the state of Wyoming from one individual to another, and there's an issue with that. Something happened. You send that examination report to FinCEN. FinCEN says, now I'm going to do an investigation on that. That is, in my opinion, a clear violation of powers in that regard, if that only happened within the state of Wyoming. And how does that work in your office? Would anybody throw up a red flag and say no, FinCEN?
Mr. Chairman, so I guess it just depends on if it's a BSA kind of violation,
right?
KYC, because they're the ultimate authority over that. Then that's why they would take that and go forward. They don't get involved if we had a violation that was within the Money Transmitter Act. If our licensee is not abiding by our permissible investment requirements, for example, and we're addressing that, FinCEN doesn't get involved in that activity because that's a state-only issue.
Right.
We would deal with that. It would be in the exam report. Obviously, when we share our exam reports, FinCEN would be able to see that finding, but FinCEN would not then get involved with the company and have an investigation about our Wyoming specific requirements in the Act. That's where we come in.
So there should be no reason to send them that data.
Mr. Chairman, I guess it's just the sharing of information about when two regulatory authorities have information. I guess it's just been kind of common practice to share the findings of your reviews. Yeah, we've never gotten into the discussion that we will only extract and send the BSA information to FinCEN. Definitely.
I think that's a definite possibility in the future, at least a conversation that we should start having in regards to sharing of data with federal agencies or any organization for that matter, considering the times we're living in and what happens with people's data. I think there's actually somebody in the room that was part of a recent documentary that could talk about owning your data. And that I think this is a bigger issue than we're actually letting on.
Well, Mr. Chair, if I can, so again, we're not sharing data. We're sharing examination information. There is no personal, there's not Tyler Lindholm identified social security number, address, date of birth in the report of examination. It's transaction number 1805. This lack of obtaining sufficient information for BSA purposes. There's no PII in a report of examination.
Yeah, but Commissioner, we just heard testimony that some data is being sent that does not need to be sent to FinCEN. You're just sending them a list of transactions that happen regardless if they're BSA requirements or not.
Mr. Chairman, that's part of the examination. So we just send the examination report. Again, there's no reason for them we can do it. If you want to pass a law that says we can't submit anything other than BSA AML only, we can figure out and do that. But what's the purpose?
Protecting our citizens. That's the purpose of the Money Transmitters Act, right?
Right. Yeah. And so part of I'm saying we're not protecting the citizens by sharing a report of examination with other regulatory agencies. We have that already in place with banking and in other areas as well.
Following up on that,
Mr. Co-Chairman.
though, I'm sort of curious. Do they need to see the results and the actual queries and the information about the individuals and everything you did, or do they need to know you did it?
So again, they don't see the results of individual queries. They only see if there was a problem if there was a violation or if there was a finding associated with that, whether it's the Money Transmitter Act or the Bank Secrecy Act, the Wyoming Money Transmitter Act.
So you're not sending them necessarily the relevant PII associated with it. You're keeping that. You're just saying, hey, we flagged this.
Mr. Chairman, yes, that's correct. Right, and okay. Mr. Chairman, there's also MOUs in place. We have MOUs in place with with FinCEN and other states. I think that the sharing of regulatory findings amongst regulatory agencies is very commonplace. Not only in the money transmitter world, in the consumer credit space, We share findings, states share findings of examinations of entities that operate in multiple states, because I think it's an important regulatory tool to know that, oh yeah, the state of California did an examination of a company that we also license, and they had this finding. So we can, kind of look for that when we're doing the course of our examinations. I think it's a good tool, a regulatory tool, to know what happens in other states in totality.
With all of those MOUs in place, we were talking before about reciprocity being maybe a vehicle to getting this bureaucratic hurdle burden down. It sounds like you're already working very well together, even though you have 53, I guess, based on what Representative Olson was saying, 53 different entities that you have to register with, but everyone's working reasonably well together. Is it true that everyone's working well together? Or are there a few states that sort of do it their own way, or is everyone pretty much on the same page with how this works? Apparently, according to Ms. Long in Alabama, they don't have a substantial surety, but are these generally the same law? Are they pretty common?
Yeah, go ahead.
Mr. Chairman, yes, I think that the actual regulation is very common, from state to state, and some states have a more robust regulatory system than other states do.
Well, on that point, I mean, if you were to go through and do a review of the 53 states and territories, how many of them would you feel were satisfactory if you were to just have an implicit trust relationship and say, all right, well, if it was good enough for you, it's good enough for us? And this is off the top of your head. I'm not going to hold you to it, but do you have a sense of that?
Yeah, go ahead.
Mr. Chairman, I guess I'm not real sure, because again, it gets down to the way that they're currently done. It's we do an examination as a coordinated kind of unit. A multi-state exam team is put together. In the course of that review, then you're looking at, instead of doing, if it's a 10-state team, we're spreading out some of the reviews. Like if we're doing an assessment of management, for example, just the quality of management during that, we're doing one review of that, and then the findings are shared with the states, and come to a consensus on all of that.
Right, Mr. Chairman, sorry to interrupt, Joe, but I'm saying more for the licensing side and just getting all of your boxes checked. It sounds like the current process for the examinations actually is a cooperative endeavor that probably works just great, honestly, for large corporations, maybe not for little ones, but I'm not as concerned about that. But when I'm having to sign up, if I signed up and am being regulated by the state of arbitrarily Michigan, do we really need to have them do it all again in Wyoming, or can we just crib Michigan's answers?
Mr. Chairman, and so that is the initiative. Absolutely. And again, that's that balance we're trying to find, that again to ensure the legislature has the authority that it needs and the state of Wyoming has authority, but also working across state lines. And that is exactly what that licensing program that we're now part of. That there's 24, so we got about half the states now. Are the other half, is it difficult once you get past the 24, 25? Probably there's some of it, but that is definitely, the NMLS has helped us, the nationwide multi-state licensing system, because there's one document upload that can then be dispersed across this system. So there's processes. I'm not going to say it's perfect, and obviously I mentioned we now have just our second money transmitter examiner. I don't know how many the state of Texas has, or state of California, or state of New York. I'm guessing a lot. So they would probably look at Wyoming and say, well, that's cute, but we're really we've got the muscle to do this, but you can tag along. My view is that I don't want California or New York or Texas telling us what's best for Wyoming citizens, especially the coastal states. That could be problematic, but it's not perfect. I'm not going to sit here and say that it's been perfect, but we're trying to make that patchwork quilt, if you will, more seamless, but yet strike the proper balance.
All right. Mr. Chairman?
I had Representative Olson next.
Sure. Thank you, Mr. Chairman. I want to jump back to the FinCEN information sharing. I understand the report. I get the report, but under 314B of the Patriot Act, so the 314B rule, that allows institutions in Wyoming to share information with other institutions. Is that information that is shared is that report based like what you're talking about? Or is that, when we get down to the nitty gritty of the actual information of Wyoming citizens being shared with private institutions under 314B, what does that look like?
Yeah, go ahead.
Mr. Chairman, Representative 314 B check. So again, I'm not a jammer in this, and so I couldn't tell you specifically all the information. But there is that information. In fact, the banks alike, all of them are required to do the checks to ensure that they're not operating with a known bad actor, right? A known money launderer, drug trafficker, child traffic, human trafficker, things of that nature. So in that, is there PII? I'd have to. I couldn't tell you off the top of my head what all of that information is, but there very well could be. But that again, that's not state statute.
Ms. Long.
Mr. Chairman, just following up on that, but I'll have a separate question later. It's not state statute, but it sounds like the feds are forcing you to narc on Wyoming citizens. And when there's a transaction that's flagged, the transaction gets reported, and if they don't have their own examiners, they're relying on you. And they have power to get into the Wyoming banks and force the Wyoming banks to disclose that information. So this leads to my next question, which is back on this P.O. box issue. This is going to become an accessibility to the banking system problem for Wyoming citizens. And what can we do about it? Why do the banks even have to have our address? Is there something that that kind of PII, personally identifiable information, the banks don't really need it. And if you think about how many times that information is transmitted from institution to institution and done insecurely, this is part of the reason why our personal information is so hackable. It's a problem. What can Wyoming do to stand up against the federal laws on this matter?
Can you say anything besides BSA, Commissioner?
Mr. Chairman, AML. Mr. So I understand what you're saying, and if there's any bankers in the room that want to talk about that, again, I think the discussion is now getting much broader than what we started out this morning. The Money Transmitter Act, Bank Secrecy Act, it is a federal law, and yes, the MSBs, money transmitters, banks, trust companies, they are subject to various aspects of the Bank Secrecy Act. That is outside the scope of anyone here, unless you can find a way that exempts Wyoming and Wyoming institutions from the Bank Secrecy Act. I don't know how we do that, but that's probably one where we rope in our federal delegation and say, okay, let's have these discussions. But is information shared through some of these things? Probably. Is there a way to fix that? I don't know. I can't even speak on that right now as to what a fix is, because again, we're now talking about federal statute.
Further questions for the Commissioner? Seeing none? Thank you very much, Commissioner. Really appreciate your time and your staff. Thank you. We're going to go on to, we're way behind the ball. Yeah, we're going to go to public comment on what was presented by the Division of Banking. We're going to move on to legislation next. So if there's any public comment on what was presented by the Division of Banking.
Mr. Chairman, Mike Giese with the Wyoming Bankers Association. My association would like to support the Commissioner's comments that he made on that issue, specifically that we'd like to see that type of transmission, the money transmission, regulated within the state of Wyoming, where the consumer protection that exists that way, not Stanford.
Mr. Giese, you're representing the Banking Association right now?
Yes.
Okay. Banks don't have to get money transmitters licenses?
That's correct.
So you're supporting keeping the money transmitters licenses in place, even though your organization has nothing to do with it?
That's correct. We're supporting the Commissioner's request for not to repeal the money transfer.
Okay. Any questions for Mr. Giese? Seeing none. Thank you very much, sir. Any further public comment?
Just quickly, I just wanted to say that.
Which, by the way, welcome to the task force, but you have to say who you are and
Right. Okay. Yeah.
and who
sorry,
you're
I
with.
apologize. My name is Spencer Kazara. Recently started a blockchain-based business here in Wyoming, and I just wanted to say that as far as regulatory burden, I would not have started this business had the recent exemption for virtual currency been put into place. So it is a very real thing, and I echo the sentiments of most of you up here. So I heard the question asked whether anyone had heard of that happening, and I just wanted to publicly state that yes, it does happen. It's very real. The cognitive load in general of just the overall regulatory burden is just a lot, and so removing part of that cognitive load definitely gives you a little bit more confidence in approaching that aspect of it.
Go ahead.
For your experience, does the regulatory burden or the appearance of regulatory burden affect the actions you take, the choices you make,
100%.
what you choose? Okay. Thank you. Definitely.
It's kind of a side question. Are you from Wyoming and you started your company?
That's correct. Yeah, born and raised here.
Awesome. Well, cool. And you started that business because of the actions of the legislature and expanding this space was helpful.
Yep.
Awesome.
I actually hadn't had this business in mind for a very long time. Looked into the regulations in the beginning and just went, not for me. And then, fast forward a little bit, see the regulation and the movement happening, and decided to go forward with it.
Awesome. Any further questions? Yeah, Representative.
Spencer's a true crypto believer.
It's true.
Right on. Seeing no further questions, thank you for your testimony. Really appreciate it. Any further public testimony in regards to what was presented by the Division of Banking? Seeing none, we're going to go ahead and move on to 20 LSO 58 version 3, Wyoming Money Transmitters Act repeal. Alyssa, do you want to present that? It's essentially just a repeal of the Money Transmitters Act.
That's correct, Mr. Chairman. Tamara Ripley here. On page 4, you see the meat of the bill, which is that Section 2 repealer. The rest of the bill is conforming amendments to take out references that need to be taken out, and I can walk through those changes if you'd like.
I think we got the general gist of it. Yeah, thank you, Tamara. Any questions for LSO from the committee? Seeing none, we're going to go on to public comment. Well, we'll ask for Division of Banking. Did you want to speak towards this legislation before? I think we got your gist. You don't like that. All right. We're going to move on to any other agencies. Secretary of State, you want to weigh in on money transmitters licenses? All right. ETS? Missed opportunity. Public comment in regards to the repeal of the Wyoming Money Transmitters Act. Any public comment? Anybody? Seeing no public comment, we're going to close public comment. Committee, what's your pleasure? Moved by Representative Olson. Is there a second? I think I had Representative Western first on the second. Committee discussion. Yep, go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. Where I'm left at this point is not supporting the repeal, but supporting an effort to create a carve-out where we can have startups not be afraid of the regulatory burden and bureaucracy in the state of Wyoming, so that cases like we heard a few minutes ago don't say, all right, I don't even want to try. And I think we can do that while maintaining money transmitter regulation for the larger entities that may or may not need it. But the reality is my biggest concern and the thing that raised the red flag for me was credibility in what we're doing here with the rest of our work and ensuring that we are recognizing the need for consumer protection at the same time that we're moving forward with these innovative concepts. I do feel that if we just start repealing things, we'll create an adversarial relationship between our Division of Banking potentially in the state and the feds as they are looking to oversee these activities, and we do increase the risk of being told what to do. So what's the least action we can take that accomplishes our objectives without shaking things up? And I think that is working on a piece of legislation that carves up for startups some micro entity language, just like this is all over government, right? You've got a small entity that has exemptions from a lot of the requirements as long as they report that they exist, and still have the ability for oversight. And then the other thing we could look at, in my view, would be really focusing on the reciprocity concept, where if another state accepts it, why would we have to have a burdensome double requirement? And maybe we don't need that. Maybe we can work with the Division of Banking. So the legislation as we have it right now, a full repeal, is not something I would support, but I certainly think this is an area where we can do a lot better and not be burdensome for startups. And in fact, if we put in place a regulatory structure that works well for startups, then we could be encouraging them to come to the state of Wyoming and innovate here. Those are my thoughts.
Yeah, Mr. Chairman, and I think as we took testimony from the Division of Banking, I think a lot of folks are kind of moving that direction. And it's an interesting perspective. One aspect that is definitely missing from the presentation, which was great, is the amount of organizations that have actually been regulated by this and actions taken by the Division of Banking in regards to them not complying with their license. And typical of government, we have these licensure regimes out there, and as long as people renew their licenses and nobody calls, then we just keep taking their money, and they get a new piece of paper every year. And so for me, that's problematic based on the very outset. Now, obviously, when it comes to licensure, it'll come no surprise to anybody. I'm against it all. But we do have to be real about this, and I do think Senator Rothfuss has a good idea in regards to, we have always given Commissioner Faulkner more work. We have not. We have never been like, let's take some work away from his office. That has not been our mantra. So I do support Senator Rothfuss's idea, but I think when we go to vote on this committee, it would be my opinion to not do a roll call, to do a shove to the next meeting, to keep that repeal bill alive, and then let's have the discussion about Senator Rothfuss's idea, move that bill also, and give Commissioner Faulkner the opportunity for a lot more work. And that, I think, that way we've got both pieces. Yeah, Commissioner, go ahead.
Apologize, so and we can have discussions between now and the next month, but are we focusing this in context of blockchain task force scope, that it's blockchain and crypto related? Because I want to make sure as we look at this and we delve into that, if working on it from that angle, or are we talking more broadly outside of blockchain and crypto?
Yeah, and that's a good point, Commissioner. What ended up might happening in that situation, if this is not blockchain or crypto specific, then if we do develop legislation in that regard, then most likely it would have to be sponsored by the legislative members of the committee if they so choose, if they wanted to.
Mr. Chairman?
Yeah, Ms. Long.
Along those lines, it's probably not the purview of the blockchain task force to do something related to this address requirement, but we can't leave that sitting out there.
Right.
It's much broader than blockchain, and I would propose that we actually send letters to the DC delegation as the blockchain task force now, saying that we're aware of this issue. It's keeping Wyomingites from getting new accounts, but what's going to happen is that it's going to start becoming broader as existing accounts go through compliance reviews and start getting kicked out. And to the earlier conversation, the deputy commissioner said that what would happen is that if a bank only collected a PO box, that it would be flagged as a transaction. In my experience, what's going to happen is that the banks won't even let it go that far. They'll just close the account because they don't want a KYC violation. So this is a real, accessibility to the banking system issue for not an insignificant portion of the population. It's new. I would encourage us to actually, as the task force, make our DC delegation aware of it and try to figure out ways to make this issue a non-issue by not allowing the banks or not forcing the banks to collect that kind of personal identification information that they don't really need.
Right. And to that point, I view that. I mean, we keep hearing, well, this is federal law. We can't do anything. We also heard that a couple of years ago about ICOs. We heard that a couple of years ago about, and the list goes on. So I think maybe there is something there. I don't know. Put a couple wild cats in a bag and see what happens. We might figure something out. Senator Nethercott.
Mr. Co-Chairman, I mean, on this topic, I guess I'm somewhat confused. So the banks are requiring a physical address. Even in a rural location, you have a physical address, even if it's not your mailing address. So I'm assuming the form says mailing address and physical address, as it typically does. So even though U.S. Post Office doesn't deliver to Representative Lindholm's Windy Way address, I think that's still his physical address and would be sufficient for the bank. So, I mean, if the issue is we don't want the banks to know that where you live in order to perhaps do service of process or other types of issues as it relates to necessary information to you, it seems to be a somewhat pragmatic issue as opposed to banks trying to access all of your PII and there's a bit larger conspiracy. It just seems somewhat pragmatic to provide a physical address.
I think I can actually clear that up for you, Senator Nethercott. The issue that's happening is that because it's 2019 and there's a lot of, I mean, the issue is not the community banks. They're doing a wonderful job of AML, KYC. There's no issues with the community banks whatsoever. The issues are, because it is 2019, there's multiple people opening up online accounts. And so banks have developed ways to do that verification process. And that verification process relies on the federal government mapping out addresses. Unfortunately for us in the state of Wyoming, they have done a really bad job of that in the state of Wyoming. And rural residents cannot get online accounts in a lot of situations unless they're walking into a community bank. And so it's a barrier to a lot of people. And that's a real deal. It's happening. I don't know what the solution is, but it is a situation. Community banks are not the issue. And AML KYC requirement, I think that's a broader scope question. But as far as how that verification aspect is currently happening under our existing law for rural residents in 2019 with online accounts, it's not a working situation for Wyoming residents as it currently stands. Ms. Long, does that kind of
It does, Mr. Chairman, and there is another piece of this, which is that there are a lot of folks for a whole host of reasons who don't want to disclose their home address and would rather use a P.O. box for privacy reasons. A whole host of them, myself included. So being forced in order to have access to the financial services industry to disclose that information, which puts some folks in this industry who are very security conscious for very good reasons, to disclose that information is a real problem.
It's the premise of prove that you're not a terrorist. You're not the U.S. government doesn't actually think that you're a terrorist pre-2001, but now they do, and you have to prove that in order to enter the financial market. That is a real thing.
And once that, Mr. Chairman, if I may, once that information gets disclosed, it gets shared. You cannot control once you disclose it to a private institution, either whether that private institution is going to voluntarily give it to the government for whatever reason. Not that the government doesn't already know that, where you live, but it's really that it gets shared with other organizations, and you have no idea. You have no way to control your privacy.
Mr. Co-Chair.
Yeah, go ahead, Senator Nethercott.
I mean, if I may, just kind of looking at it all realistically, and I don't want anybody to have my private information either, but it seems somewhat moot. When yesterday morning we were just talking about all of the public records for land transactions and who's the deed ownership and being able to search that in a searchable database, and that's how it is now, I believe. Representative Western has a very fancy app where he can pull up all the deeded ownership in this entire region, identifying all that information in the effort for transparency of government action and all of this government records. So I don't know if the tail is wagging the dog here or not, but it seems to be a minor point at this age of transparency of government documents.
Mr. Chairman?
Yep, Ms.
If I may
Swan.
add, it's a wonderful thing that Wyoming LLCs do not require disclosure of personal information. One of the reasons I came back. And owning a personal residence through an LLC can keep that data from being searchable by stalkers. And I'm dealing with this personally. Thanks.
Yep, go ahead.
I don't know if we know this answer, but not that they would, but I assume that they could. Can banks market and sell the data that they receive from KYC? Does anyone have an answer to that? I don't know if there's anything in KYC that prohibits them. Does that then become owned information in addition to having to be reported verified? Ms. Channing seems to have an answer to that.
Go ahead and come on, Ms. Channing.
Mr. Chairman,
Yes.
my name is Emma Channing. I represent Consensus as my own. I think this conversation is getting split from the reality, which is the Equifax hack. That it's once this information is in the hands of the service providers, then a question of how secure they are. And these things get hacked all the time. And I want to second, I don't know exactly what Caitlin's situation is, but particularly for women in blockchain, harassment is a real thing. People finding where you are, where you live, and telling your house is a real thing.
Mr. Chairman?
Go ahead.
Well, there may not even be a need for a hacking, though. I mean, that was really my question. Yeah. I was part of the OPM hack, so there's a lot of people that have every bit of information about me from, I guess, age 0 through 32-ish or something like that in my life. They know everything about me. Handy. All of you could probably search for it and get it off the dark web anytime you feel like it. But we have so many just openly available data sets that are for easy purchase that you may not need to hack. And I'm curious if we're actually through KYC providing a much easier path than having to go to the trouble of hacking by just requiring that all of the information, detailed information like Ms. Long's talking about, address and everything else, is a requirement to be fed to our financial institutions that can then sell to marketing entities or whomever else feels like purchasing the data set. And I assume that's just fine. Again, not to say they're doing it, but some of them certainly would be.
Ms. Channing.
Mr. Co-Chair, I would suggest that that is very much definitely what's going on, and that's what these service providers are in the business of doing. Whether or not they may have sought consent to do that or acquired at a federal or state level, I wouldn't quite know, but a lot of these companies operate under NDAs and other ways that make them comfortable sharing and then reselling that information.
Thanks. Any other questions for Ms. Channing? Thank you, Ms. Channing. Really appreciate it. So back on point, committee.
Mr. Chairman.
Yeah, okay, we're back. Yeah, go ahead.
Yeah, back on point, Mr. Chairman. Since I made the motion, yeah, I don't want to vote the bill up or down, but I think the idea is to come up with continue that bill, lay it back, but have an alternative bill with the exemption. The question is, what is the threshold for the startup? You know, I'd like to see LSO prepare us something for the next, but we need to set it. We need to set a threshold. Probably, I mean, is it going to be based on just a new company? Is it going to be based on the net worth? What is the exemption?
Mr. Chairman,
go ahead.
It seems to me that the unit that they use, based on what I heard, was how much outstanding. It's not debt. It's what's that? Maybe we can invite the commissioner back up, or Joe back up. There was a term of art you were using with the outstanding value of the asset.
Outstanding payment instruments.
Outstanding payment instruments, the value of that. Right. So I guess the question is, what do you see as small? What is a small number for that, and what is a large number for that in the state of Wyoming?
And Mr. Chairman, you know, again, I think we're going to have to, you know, work with LSO and try to, you know, come up with this because, you know, the outstanding payment instruments to determine the bond is looked at obviously kind of on a daily basis. And so there's two things, like Commissioner Faulkner said, under the Money Transmitter Act. It's the actual transmission of money from here to here, or there's the stored value. So most of the outstanding payment instruments kind of get into the stored value products, something that happens and it's outstanding at the end of the day. Those are, and those keep building. If I send you money and that transaction or that transmission happens instantaneously, there's no outstanding payment instrument at the end of the day. And so there can be a lot of volume done during a period of time, and then that ultimately results in companies having zero, reporting zero on their average daily outstanding payment instruments, because all of the transactions are settled at the end of the day. It's only when a transmission occurs and then it's not settled on the back end, or you get into the situation of the stored value products, the sale of money orders, or again, for like the Venmo account. If I send you money and you receive it, then that's the sending of it is the money transmission. But then you have the stored value aspect, and so the volume that you're holding in your account is then added up. And so, are we going to talk about transmissions, or are we going to talk about the value of outstandings?
Mr. Chairman, I guess I'd ask you what makes more sense. Now it sounds like maybe transaction volume, monthly transaction volume, or something along those lines is the unit that we would want to use as our criteria for this is de minimis. And again, what would be large for a monthly transaction volume and what would be small?
Yeah, Mr. Chairman, I think I agree, yes, because it seems like that when you're looking at the risk, where is the risk? If the transmission happens immediately, I send the money, you get the money, there's not really a lot of risk there. The risk comes in primarily when I send you the money, but on the back end, it takes you a week to get into wherever I sent it to get that money. They have to protect that money. They have to make sure that money's out there. Or for some of the other products that are out there, that do fall under the Money Transmitter Act. I think that these days, a lot of things people don't realize when you're in the grocery store and you walk by the end cap that has all of the gift cards on there. A lot of those are offered by one company, even though it's got all the different types of gift cards that you can buy. The actual company offering that is in a lot of cases just one company, and so that one company is selling all of those gift cards. They fall under the Money Transmitter Act because all of those stored value products have a balance on them, and they have to maintain permissible investments to ensure that when consumers are buying those and they're going to use them, then you're going to have the value that you're supposed to have on those cards. And so, it's those kind of stored value products, that primarily are going to add up. And so, I think that I know you threw out $10,000. That'll probably add up pretty quickly. I'm not sure what the appropriate number is, but I think that's where we're going to have to work on.
What about an OR concept where we have a value for outstanding stored value and an OR transaction volume if you reach either threshold, and then we come up with what those thresholds are? Does that make sense? It seems like you're covering all your bases at that point. If you stay below both of those thresholds, you're deemed a low volume or a low risk entity.
Mr. Chairman, I think that those are things that we could definitely explore.
Okay.
We're making sausage now, folks. Thank you, Joe. Appreciate it very much. Gift cards. We also escheat those at the state. That was my first blush with realizing how big government actually is. Yeah, when you realize that we take gift cards and we hold them for you forever. It's wonderful. Forever. We do. It's so silly. Anyways, committee. So we've got a motion and a second. My opinion is we do not. I want to handle that first. We are not going to be doing a roll call on that. Yeah, just withdraw.
Yeah, Mr. Chairman, no, I think I'll just amend the motion to table it, or just withdraw.
Don't table.
No. Let's but I want that bill drafted for the next meeting.
LSO, are we within the color and within the line still?
I might comment on a few items. First, I did want to point out that the last year's Financial Technology Sandbox Act did provide an exemption, so that's a 2-year exemption. That does go to some of the startup entities you're talking about, but I think you're talking about also continuing exemption for entities that have low value. So I think I hear that distinction. I don't have a lot of details about the reciprocity aspect. Is this just an exemption from Wyoming entities?
That's a separate aspect. We're going to jump right into that real quick. But as far as the repeal bill itself, we're all right shoving that off to the next meeting?
I think absolutely.
Okay. Great. Senator Rompus, do you have a motion? Go ahead.
Mr. Chairman, I would move to have LSO draft legislation that would provide a carve out for the Money Transmitters Act for corporations or entities, however it's defined in the Act, that have either a low stored value, and we'll work with the Division of Banking to figure out what that means, or a low transaction volume on a monthly basis.
There's a second. Would that also include the reciprocity aspect?
Mr. Chairman, I was thinking those are two separate concepts sufficient that we could deal with them separately.
Committee, does everyone understand the motion? Is there any questions on the motion? Seeing no questions, this is moving to draft for the next task force meeting. All those in favor, please signify by saying aye.
Aye.
All those opposed say no. Motion carries. LSO?
Mr. Chairman,
go ahead,
on the
Senator.
reciprocity, honestly, I think we just need to hear more about it next time. I was trying to think of what that bill would look like, what legislation would look like. I feel like we asked them enough questions this time that I wouldn't want to. I'd want them to go back and think about what that legislation might look like if we were to try and come up with something that encouraged reciprocity, particularly in light of the fact that they're already working on some type of reciprocity. So it might be premature to get something drafted. Those are my thoughts.
Division of Banking, Commissioner Fortner, is that all right with you? Would you be willing to update the committee at the next task force meeting in regards to reciprocity aspects and what could be done or shouldn't be done?
There might be a model out there. We got to see if the state has it. We're thinking Alaska might have something. I don't know what it looks like. So there could be something to work with. We'll do our best. So also trying to get rules done for SPDIs too. So we'll squeeze that in there.
Speedy Bank.
Yes.
Speedy Bank.
Speedy Bank's more important.
Speedy Bank's more important.
Mr. Chairman?
Chris to put it on his list of things. Perfect. Perfect. Need more work. Yep.
Mr. Chairman?
Yep, go ahead. Representative Yen.
Thank you, Mr. Chairman. I think it might be interesting for us as a task force to maybe just express our desire for the bank commissioner to at least bring to their conference of state bank supervisors a discussion for talking about reciprocity, because I think that makes sense as the best place for that discussion to formate and create, since it's going to have to work with other states to determine what reciprocity actually means.
Okay. Any further comments or questions in regards to the large can of worms we opened? Seeing none. Committee, we're going to go ahead and take a quick break. Let's do a 10-minute break. Be back here at 10:55. And then we're going to jump right into personal data trust services. Hopefully we can get that knocked out because we're behind the 8 ball and we still got to pick up stuff that we didn't get done yesterday. So with that, we are at break. to jump right back in committee. We're going to jump back into personal data trust companies. The Division of Banking, if you would be willing to come up to the table, specifically in regards to personal data trust companies, a lot of those issues on why we're looking at that were brought out in the last conversation, has to do with information being held privately. We're waiting on the Division of Banking Commissioner. Commissioner Faulkner answers to no ma'am, except for the Department of Audit and the governor. Okay. Mr. Land, got to announce who you are, who you're with, etc.
Thank you, Mr. Chairman. Christopher Land, General Counsel, Division of Banking, Wyoming. Are we good to go, Mr. Chairman?
Pardon me?
Are we set?
Yeah, no, we are taking testimony.
Okay, so I'm going to start at a very high level, and I can go into as much granular detail as you'd like. Just
very high level, that'd be great.
Okay. So kind of the discussion that we just had about AML, KYC, customer identification is built on kind of a different premise. The premise that we need to share all kinds of data and to be verified manually through, either manual review or a computer. An interesting concept that's kind of emerging in the digital identity space is kind of the attestation verification process, where a third party could hold your data and transmit some kind of secured verification to a person who needs the verification of your identity. And inherent in that concept is there are two kinds of models. One is the consumer protection model of how you manage data. It's similar to what the European Union has done in their general data protection regulation. It's more, it's more customer protection, consumer protection focused, where you have certain rights, where you can go to a person who's holding your data and have a statutory right to demand what data they're holding from you. To demand that it'd be updated or sanitized to reflect your true information if it's incorrect, to delete your data in certain cases, and to prohibit that company from selling your data to any third parties. So that's the consumer protection model. California and Nevada have just recently, in the last few years, adopted the consumer protection GDPR focused model. And the other kind of model is kind of a more property-based, property rights approach to owning data, to having a property right in data. What that looks like. It could be more of kind of a water right, where you have certain limited rights around it, or it could be, kind of an intangible personal property right in data, where you have the bundle of sticks, as they call it in law school, where you have certain rights to monetize your data, to control it, and to push it out there.
Mr. Co-Chair?
Yeah, go ahead.
Just
Senator?
because Mr. Land referenced the phrase bundle of sticks, which we lawyers like to use frequently, does not give carte blanche authority for the rest of you to start saying bundle of sticks as frequently as you can.
Understood, Senator Nether.
Careful with our phrases, Mr. Land. They'll
Mr.
abuse
Land,
them terribly.
If you could kind of bundle up this group of sticks.
Into a bundle.
And
I've started a phenomenon. I'm sorry about that.
Let's bundle it up.
But the collection of rights that you have in data could include dominion, control, a sale, leasing, dividing your interests in data, restrictions, the duty to hygiene the data, abandonment, and security interests in your data. So it's basically like owning some intangible personal property.
Go ahead, Mr. Co-Chairman.
I realize we need to let him go through his presentation, but the Nevada, California was first, Nevada was second. Is that right?
That's correct, Mr. Chairman.
Did Nevada basically copy paste California?
85%, Mr. Chairman. They made some Nevada specific tweaks, but it's substantially similar.
Around your gambling winnings and things like that.
Of course, yeah. No, they just changed some of the definitions.
Okay.
And, yeah.
All right, thank you.
So those are kinds of the two models at the highest level. If you want to regulate this space, that's kind of the policy decision that needs to be made, is whether you want to follow the consumer protection approach or the property rights based approach to data. Some other issues that are kind of bumping around in the space right now are the issue of data trusts, kind of a trusted third party to hold on to people's data. And for example, you know, an interesting use case for a data trust is they could hold, certain pieces of personal information, and then if a financial institution needed to verify, your AML, KYC, et cetera, data, they could rely on a verification or an attestation from the data trust to comply with their customer identification issues. That being said, that would require significant federal involvement and approval for that to kind of be implemented in the financial institution space. Kind of a more simple model is, you walk into a pub or a bar, and the gentleman outside who's checking IDs, he doesn't need to know your address or your height or any of that other data. He just needs to know whether you're of legal age to enter the establishment. And that's, you could have an app that you scan a QR code and it says you're of legal age or whatever, and you can enter the bar. That's a very basic application of that. Some other ideas that are kind of moving in the space too, other than data trusts, identity credential standards. Developing the precise technical standards that would be needed to create a digital piece of digital identity that could be transferred between institutions and data trusts and governments and businesses in a more effective way. The state of Virginia has done quite a bit of work in this in 2015. They had a piece of legislation passed, and they created a task force, and they've been working over the last 4 years to develop an identity credential standard, and they actually have hundreds of pages of documents on an identity credential. So with that, that's kind of the broad outlook. I'll just kind of repeat myself because I feel like I may have skipped over the data trust piece a little bit. So at a high level, the policy choice would be whether you adopt the consumer protection or the property rights model. Then the data trust could be a potential vehicle, a trusted third party to hold people's data, to make attestations and verifications to businesses and governments. And then kind of below that at the more granular level is digital identity standards, kind of the tech stuff, how it would be transferred and identified, et cetera. And with that, Mr. Chairman, I'll see if Albert has any comments.
Commissioner Faulkner.
Yeah, Mr. Chairman. Thank you again, Albert Faulkner, Commissioner Banking. We've had a lot of discussions, as Mr. Land said. There's a whole host of things to consider in this, and it's the topic obviously started discussing last year. Vermont looked at the space as far as personal information protection service company or something like that, has gone nowhere. And the reason, at least what I think, what we were kind of looking at it, there's still a lot more questions and answers in that the legislation, and so I don't think they accomplished anything other than they got some something on a piece of paper. So I definitely think got to answer some of these fundamental questions first. And while the idea sounds fairly easily implemented, there's a lot behind it, I think, is the issue. Also did want to highlight that one of the considerations, I know we said this trust company, and last year it kept morphing as to whether maybe even just a certification, but the thought is, it was kind of always hovering around financial institutions. And I guess one of the questions I had come up with is, let's say Chris and I are developers, and we have this great idea that we've got the top-notch data protection software and infrastructure in place, and we want to put ourselves out there. We want to start a business that says we are data protection specialists. Come to us. But we don't want to be a bank. We don't want to be a trust company. Our business is data and protecting that data and maybe transmitting it if and when needed. And so I think we need to consider that business model too, that's outside of financial services. Obviously, even though the discussion the last hour was about the data that's shared within financial services, absolutely. But we walk around Target shopping. I walk out, they know who I am based on what I shop. They were tracking me and what I was buying. So there's even that kind of information. So, but I did also want to highlight one other thing that. Again, looking at the state system and the strength of it. So CSBS, Congress is looking at this as well. The House Oversight Subcommittee on Economic and Consumer Policy has tried to look at data protection, and I'm sure there's other members of Congress looking at it. We have supported that. And a little pat on the back to the state system, the Equifax breach that occurred while our federal colleagues, the various agencies were trying to figure out who or what authority they may have had. 8 states went in and did an examination and issued a formal enforcement action against Equifax while the feds were deciding how to even tackle this. So we were in and out of there before they in DC had answered that question. Now, that being said, there's a lot to be done in that space, but the discussion is, state level, it's national level, and it's really global level. But there's a recognition of it, and definitely understand the complexities behind that.
Questions for the Division of Banking? Seeing none. Was that it, Commissioner Faulkner, before I have more public comment?
Yes.
Okay. I really appreciate bringing us back up to speed. It's one of those aspects that I don't know when we find the wheel for that deal. I think it's out there. It's just where and when and how and if it's necessary.
Well, Mr. Chairman, and I think, again, the fact we're still discussing it, one, highlights, again, the complexities behind it, the unanswered questions. But as every day goes by, there's more and more momentum because there's more and more of a realization of how much data is out there. And you alluded to one of the individuals in the room that highlighted that on a very public scale for all of us to benefit from. And as I was telling her about talking to my 20-year-old daughter about just signing up for apps and willingly clicking acknowledge, and not even paying attention to what you're giving, then what is the consequence of that? So I think even the education piece is very important. And in a lot of aspects, it's got to start there because, well, I'd signed up for the app, I click this, and, who cares if they're tracking me? I'm just, I want to know where my friends are. So if I look on Snapchat and where they're located, that's fine. Well, what's the consequence and what's the cost of that? And so we've got to have those discussions as the same time that we're trying to find out behind it.
Yeah, go ahead, Mr. Co-Chairman. Do you want to talk about your inner libertarian?
Yes. I was just going to note that I always tell my kids as they're clicking through and, telling me about this great free app they have, that nothing's free. Either you're the customer or you're the product. So if you didn't pay for it, you're the product.
I think a really good example of that just recently hit was that face changing app, where you could see how you would look. Yeah. What the reality was that was actually developed by, and not that Russians are evil, but it was developed by a Russian group that was actually data mining. And I came home and my wife and kids were playing with that app, and I got to playing around with the app too. And then I said, maybe I should look into this real quick, and found a ton of articles showing that it was actually kind of a nefarious group, and immediately apps were deleted. But it was too late at that point. Yes. I was mined. So anyways, I think it's an important aspect. Ms. Long, I think you've got a comment.
Mr. Chairman, a question for the banking division. You were working on language. Do you think that for these data trusts, and I understand that Governor Gordon's excited about this concept, is it not ripe yet, or can we do something?
Mr. Chairman, Ms. Long. So the language was based on last year's discussions. If we're going to make this a trust company, was sort of where it started. And if you remember, it just evolved or devolved with each meeting, and because of the uncertainties out there. I think the governor's understanding or appreciation of this is the digital identity space, and there's a lot to be there. There's a lot of opportunities. Again, I'm not here to speak on behalf of the governor, other than I think he's acknowledged that a number of times that there probably is an opportunity. But I would go back and say again, based on looking at the state of Vermont, and as Chris said, even Virginia's looking at 4 years of still trying to sort this out. Vermont's got no traction yet with what they put on the books. So we need to figure out, is it ripe? Absolutely, but it's so complex. What is the entity? What's the vehicle? And what's the regulation? And also, based on previous discussions, do we want that barrier? Make sure that there's not some sort of barrier to entry to those people coming into this space. How do we handle that as well?
Yep. Go ahead, Mr. Co-Chairman.
Yeah, and we certainly have gone back and forth on this. It's hard to find a way to thread the needle, but we we know we do want to make sure that it's not an exclusive entity where the only people who can hold data are personal data trust entities. We know that our banks can already theoretically do that to some degree. We know that other entities can do that. But what we'd like to be able to do, though, once again, is have an entity that wants to voluntarily enter into an audited, regulated regime, governance, and be able to confidently say, yes, this personal data trust is credible. And with that credibility, then, even if it's a non-specific series of details about what it's comprised of, just having governance behind it is going to provide additional confidence. And that's what we've been looking for the last couple of years. We know that there are entities that would love to come in, start businesses, if we could provide that type of certification. Struggle we've had, obviously, and been a part of the struggle is trying to make sure that we have all of those components in place and that it's not all done by the Division of Banking, because you can't certify and audit and regulate all at the same time, or the system lacks credibility. Yeah, it's really all part of one big bundle of sticks. In no way. It is. It's just going to keep going. It's just going to keep going.
I may have done that on purpose.
But again, we've had some time to reflect on this. I know that others have worked on it. We would love to be able to put forward some legislation that creates this entity and allows the entity to be recognized in the state of Wyoming. Do we have an idea of what that could or should look like at this point? And if the Division of Banking isn't going to be doing all of it, which I don't think they should, how can we create an ecosystem around it where we have the sufficient support and resources that have a and I don't know if either of you have a suggestion on what type of program we could put together, but how would we go about doing that if we wanted to get something done this session?
Mr. Land.
Mr. Chairman, Senator Rothfuss, to the very first point you made, we don't want to. A lot of the legislation this task force has choose to move forward the last couple of years has been enabling legislation. Not restrictive, but providing legal certainty. One way to do that in this space would be to limit the liability if they hold customers' data in whatever vehicle you would choose to create. It would limit their tort liability or whatever legal liability for data breaches or whatever. But that's kind of the tail of the dog. Dog is what the vehicle is, and so there are a lot of potential vehicles out there. I think if we were to do this, we would need to bring in some law professors, some legal practitioners from the industry, and lock them in a room and come up with a vehicle that's appropriate. I think there are a lot of options. The fundamental one is determining which. Like if you want to do the GDPR type stuff, that's easy because we can just cut and paste California and Nevada's legislation. But the GDPR is very controversial. It might not work for Wyoming, and it's not the property-based approach that we've pursued in other legislation. So, I think there needs to be some hard conversations about, what your focus is and what your intent is.
Don't forget to put a rancher in that group of people also. Ranchers are hands, I've heard.
Yeah, Mr. Chairman, I believe that the chairman earlier said we need to throw them all in a bag and see what comes out.
Wildcats.
Right.
Should we put in like a bundle of sticks with the cats?
Yeah, cats and sticks.
Yeah. All right.
Cats love sticks.
Ms. Long?
Mr. Chairman, just real quickly, also, Mr. Land, you may recall the letter that we got from Premier Burt in Bermuda proposing to work together on identity. They weren't, to my recollection, talking about personal information trust. What they were talking about is trying to get some symmetry and standardization in the amount of data that banks are collecting globally on KYC. This is very tied into the original issue, which is why do all these people have to get all that information about you? Why does your address have to be on your ID that, your daughter shows a bouncer at a bar and he can just take a snapshot of the ID and know where she lives and know exactly what her age is, right? Why can't we just have some sort of accepted attestation. But the reason I'm going into this is it's the financial services, it's all that KYC requirement on identity that's the stumbling block, and every bank does it differently. And that's what Bermuda was asking for Wyoming's help with, was to try to work with the Fed to enable some sort of standardization on KYC, which would prohibit or at least cut down the amount of information that's shared. Is there any chance that a personal information trust could help us solve that?
I don't know that. Thank you, Mr. Chairman. Ms. Long, I don't know that I would call it a personal information trust. Whatever vehicle, whatever third-party intermediary vehicle, that would be one way of solving it. There also might be some decentralized options that I'm sure some of the technologists in the room might want to talk about.
Mr. Chairman, just a quick follow-up, if I may.
Sure.
Thank you. But does Wyoming have any ability to try to move the needle on those federal laws?
Mr. Land.
I'll let
if you want to.
Mr. Chairman, Ms. Long, I would like to think we could flex that kind of muscle, and I would like to think that we have the answers that they should follow. Well, I'm sure that we do actually, but I don't know. And then at that point, we need to rope in the governor's office and need to have that whatever support from a statewide official. Again, that intersection, the balance, the state-federal balance, and we're talking about federal laws. Yeah, we look to find ways that maybe shift that needle. I agree with that, but I think that's a broader discussion in the sense that if you get this right, you get this vehicle right at the state level, and you work out what exactly we're trying to accomplish, then it gets noticed. Then maybe the discussions, I think we heard this morning, the ULC notices certain actions. Sometimes they're playing catch up. Maybe that's a way to do that, to do that. But we got to figure out what is, what exactly is the approach we're wanting to do, and what is the stance that the state of Wyoming wants to take on the consumer protection or the other avenues, things of that nature.
Co-Chairman Rothfuss.
Land.
Go ahead, Mr. Land.
Thank you, Mr. Chairman. It literally is just mapping out all the possible ideas on a blackboard and figuring out how they fit together. And it's literally just, you have to think through all the possibilities and kind of go down the rabbit hole in each direction and kind of see what probably makes most sense. It takes a group of people that are very knowledgeable in this area. We're not trying to say that we can't do it or whatever. I just want to, like all the other legislation the task force has moved forward with the last couple of years, it needs to be thoughtful and directed to attack a specific problem and not just trying to do something for the sake of
it. Yeah, go ahead with the follow-up.
Mr. Chairman, when we're looking at this, though, the digital identity is an incredibly deep problem. How we want to treat the data, obviously, whether GDPR or property, is a challenge. But really, regardless of what any of that is, if it seems that the personal data trust concept or just a data trust concept can exist independent of what you have as your product. And I'm saying that because if you set it up so that it's a fiduciary responsibility for data, then you can do that in a way, or should be able to do that in a way, which is independent of what that data is, what its nature is, what it looks like. At least that's what it seems to me. Because again, we do that all the time. Typically, it's a financial fiduciary responsibility. You have financial value, and that has to be protected. What you do, how it's done, what it looks like, doesn't really dictate a different fiduciary responsibility necessarily, or it certainly doesn't have to. Doesn't it seem like the same thing with data, where we could be neutral, characteristic neutral on the data side, create an entity that has a fiduciary responsibility to whatever that data is, and kind of get ahead that way? And the reason I'm asking is, if we could do that, it would help us to then understand what it should look like over here based on having a potential marketplace and a realm to study.
Thank you, Mr. Chairman, Senator Rothfuss. If you're interested in the GDPR model, there isn't really a need for property rights and data, because under the GDPR model, like the company who holds your personal data, you just have certain rights against them. That they're custodying the data. You don't really need a data trust or whatever the vehicle under the GDPR model, because there is no third-party intermediary. It's kind of the same thing that happens today, where individual companies just hold your data, and you have certain consumer protection rights against that company. So there's no need for an intermediary, or at least not in my thinking.
Well, Mr. Chairman, part of the fiduciary responsibility, or for a data trust, isn't just that anybody's going to hold it. It's that somebody who's very competent is going to hold it. And that's a big difference between what we see right now, where we know that we have ridiculously different degrees of competence, and even those entities that come out and say, oh, we're foolproof, those are the ones that are always getting hacked. Yeah.
So again, I think, Mr. Chairman, but that's a very key distinction, though, because if you go on the consumer protection route, you're saying various entities, the consumer has the rights, certain rights, but otherwise you've got to define property right of data. And is it property that then a third party, you basically shift that over to the third party, and the liability shifts with it to that third party. But again, so you've got to start there with consumer protection doesn't need the third party. The entities have to abide by there's certain actions that can be taken against those entities that abuse that protection, and the consumer has those. But if you want to say that it's a property right or something like that then can move to a trusted third party, that's a different kind of approach.
Mr. Chairman, I think that's a false dichotomy, where we have to have a circumstance where in a consumer world, or the consumer protection world, I don't need a personal data trust service. Even if it's not property, I still want, as consumer protection, an entity that's good at it. And it's my data. And again, I guess I'm saying my as if it's property, but the intrinsic consumer protection, there should be entities that are capable of holding that I have more trust for and taking care of it, because you can't abstract it away from the fact that somebody else is holding it. So even if you're not treating it as property, it is still, it's not intrinsic to me, it's out there. So there's still value to a personal data trust, regardless of whether it's a consumer protection model or a property model. So again, I don't know why we would have to make that decision before we created a personal data trust. And in fact, it seems like we could theoretically have it both ways and still end up with a value for a personal data trust.
Thank you, Mr. Chairman. Senator Rothfuss, one of the concerns that we had about the personal data trust model over the last couple of years was how it would make money. And if you were to create property rights and create this vehicle, whatever you call it, and limit their liability or provide some incentive for companies to dump all their data into the data trust. I almost used another property.
You
property
should,
term.
because we can leverage it.
I had a really good property professor. That would incentivize the companies to pour all their data into the data trust, and to it would be a more profitable business model in that case,
Sure.
Because there would be more reliance on the trust company, and their liability would be limited. That's obviously a very, very attractive proposition for a lot of companies. They could limit their liability for data breaches.
Mr. Chairman, that's on the property rights side, but on the
Yeah.
consumer protection side, it's still true, because I still don't want, if I'm an entity that ends up using this data and I want to provide consumer protection, but I am incompetent at data security, then I want some other entity that has demonstrated their competence to be the facilitator. For example, a lot of you look at Amazon and PayPal, for example, they'll both provide you with merchant services effectively. Well, I can have my own little merchant service system, and I can program it in my basement for a while, and take credit cards and run it through the merchant service system, and then be hacked tomorrow. Or I can offload all of that risk onto one of these two entities that I know does it pretty well,
Yeah.
And I'm offloading the risk. Again, that's not saying that I have to choose a property model to do that. That's a consumer protection that I'm offloading onto them, and I'm paying them for it.
Mr. Chairman, thank you, Mr. Chairman. Senator Rothfuss, Senator Rothfuss, that's a great example of the issue. Like, we have one conception of how it would go, and you do too. Like, these are the issues that would need to be worked out.
Okay.
Yeah.
So you're saying that we should get together in a room and shut the doors?
You could very well be right, and we could, on the same, our view could be right at the same time. It's just it's so complex. You have to get down to the bottom of the conceptual ideas and figure it out.
I guess, Mr. Chairman, my only hesitancy with trying to solve everything first is that we know that the data identity is ridiculously complicated, deep, and I feel like if we're waiting until we have a full, detailed, workable solution on digital identity, that we won't be able to move forward with personal data trust, and we would benefit from getting that on the ground, even if we don't have a full description of what data identity looks like.
Thank you, Mr. Chairman. I wasn't trying to say that we needed to dot all our I's and cross all our T's. There are things that can be done. There needs to be a serious conversation with all the stakeholders and first.
I'm good. Thanks.
Okay, Senator Rothfuss has calmed down. Anybody else? Senator Bruce Burns has joined us. It's great to see you, Senator.
Or at least he wandered in.
That's
great to see you anyway, sir.
It's
Representative Western.
I was going to say it's worth noting that I actually currently occupy the seat that Bruce had many years ago. I think that was before electricity was invented, but I'm certainly glad to be having it.
Bruce invented it.
He certainly invented the firework. That we can definitely say. But no, it's great to. I just wanted to recognize the former senator and everything he's done for this county, for this town, and certainly for the state. So thank you very much, Senator, for being here. That was my aim the whole time.
And on that point, Senator, it's worth noting that he does hold the seat that you formerly held a long time ago, and he's doing a great job. That's why we're in Sheridan right now as the blockchain task force, is because one of our members is from here, and he's working diligently on your behalf and working hard and making you proud down in Cheyenne. Yeah. The Love Fest. Nobody wants to say anything about Tara Nethercott? No? Okay. I guess we're going to move on. Thank you, Division of Banking. Really appreciate it. We're going to go on to any public comment. ETS or Secretary of State's office, you guys want to jump in this one? Could end up being your responsibility someday. All right. We're going to make a wager on that. Going to other public testimony in regards to personal data trust companies. And just for the public, once again, as a reminder, you've got to announce who you are, who you're with, who you're representing, if you're representing anyone or yourself. Welcome.
Good afternoon, Mr. Chairman and the rest of the task force. My name is Brittany Kaiser. I am a co-founder of DATA, the Digital Asset Trade Association. We're a 501c6 based in Wyoming. We're a lobbying firm that specifically seeks to connect entrepreneurs, specifically technologists, with legislators so that we can help solve some of the problems that you've just been discussing. So on the personal data trust issue, I actually agree with Senator Rothfuss quite strongly that these 2 points that we've been discussing between consumer protection and data as a property are not actually mutually exclusive, and they don't actually need to be solved before we start talking about a data trust. So in order to back up, I just want to reestablish what you guys have already said, which is that this is not only an international issue, but one of the top issues that federal is looking at right now. The U.S. Congress is in constant debate over quite a few new legislative initiatives, one of which is kind of most important when we're talking about data trust, is Senator Elizabeth Warren's Corporate Executive Accountability Act, which would make corporate executives criminally liable for data breaches that occur as a result of negligence, such as in the Equifax and Facebook and Cambridge Analytica cases. So when we start to think about all of the companies, which is basically every company that exists in this state that hold personal data, they will soon start to be held to specific data security standards. And if they are not upholding those standards and they get hacked or have any other form of data leak, then they will perhaps, right now they're already civilly liable for significant fines up to $5 billion, as we recently saw from the FTC. But now we're looking at criminal liability where executives could go to jail over this. I wish we would have had this law a couple of years ago. But if we're looking at that type of liability, both civilly and criminally, there is a strong reason to give a path forward for a regulated entity that will have significantly high security standards that will be responsible for handling people's data. It would be very similar to an Experian or an Equifax model, possibly, where it's a company that collects and maintains databases and data files on every single individual in the United States, specifically most data held with individuals 18 and above. That's over 240 million Americans. So when you think about the negligence that was just proven in the Equifax case, I actually acted as an expert witness in one of the first cases won against Equifax. Their negligence was significant, and their entire business model was built around protecting personal data. Yet they did not update over 8,500 security standards and updates and patches, and they also let over 300 security certificates expire. So, do we want our personal information to be held by companies like this that are completely unregulated? I would say not. I think the personal data trust gives a massive opportunity to companies to come forward that will be much more responsible and could provide the exact same services. I mean, specifically for banks that are going to companies like Equifax and Experian in order to get a credit score, we don't know if the data that is held by those companies is even accurate or relevant or is being held safely when the most important institutions and decisions that are made by the government and by banks are relying on this information. So we have a path forward now for companies to be regulated and to openly submit to that regulation by applying for these licenses. Therefore, they could have not only more public trust, but more institutional trust. Other companies and the government could look to an organization like this to say this is a company that holds data that is legitimate, that is hygiene, that is cleaned, and that actually has a way of protecting the personal data of individuals. So whether that comes from a consumer protection standpoint or a data ownership, data as property standpoint, that actually doesn't matter at this point, in my personal opinion. Given that this is the blockchain task force and that Wyoming has been the thought leader, not only in America, but in the entire world for pushing forward opportunities for entrepreneurs to come and build here in Wyoming, I think that this is a massive opportunity for blockchain companies where actually digital identity and data management is one of the number one solutions that are solved by blockchain companies these days. And I could already tell you that there would be a massive line of people that would be applying for these licenses the second that they became available. And to Caitlin Long's point as well, earlier, solving the digital identity issue by providing a company that not only can act as a third party, so it removes liability from companies that don't want to hold personal data and might just want to have access to an API to the small bits of information that they require. So it might just be high level information, first name, last name, birth date, zip code, as opposed to everything about you in order to push forward and make decisions. There's an ability for this third party data trust to now become the licensed vehicle for which digital identity companies could become prosperous, profitable, and trustworthy. So I definitely think that I would really hope and recommend that we would be able to do something on that. And while I'm here, I also wanted to specifically talk about my opinion on the consumer protection versus data as property as well. I'm probably one of the biggest proponents on planet Earth about owning your data as your property because consumer protection isn't good enough. You just end up following up after data breaches with fines and nothing gets done. And once your data is out there, you can't get it back, unfortunately. So I think in order to ascribe property rights to your data, which we already have in the state of Wyoming. We've already defined our digital assets as our intangible personal property, and data is the most valuable of all digital assets. In fact, the blockchain tokens that we have spent so much time protecting are just blocks of data. So if we're going to go to the more basic part of digital assets and the most valuable, we're talking about personal data. And this is something worth protecting. Property rights are the most protected in our legislative framework, and we've already pushed forward with property rights as the solution to digital assets. So I think it makes sense to extend that to personal data by definition, because if you're looking at personal data regulated specifically from a consumer protection standpoint, they're saying that you have rights to transparency and legal recourse because you are a consumer, not by definition of your data, right? So you are a consumer, you have the right to know if a company holds data on you and to know that they're holding it responsibly and how they're using it or who they're sharing it with, and perhaps the right to say, I don't want to share it with these companies or these organizations, but I'll share it with those. Okay, that's fantastic, but that's because of you, not because of your data. So there is still, in the consumer protection standpoint, a complete lack of recognizing any definition for data itself, which it continues to be a massive problem when data is not only the most valuable digital asset, it is now considered by many economists around the world as the most valuable asset at all on Earth, yet somehow our legislative framework has not defined it. So consumer protection is not enough. And it's completely compatible, in my opinion, with the property rights framework. You are protecting somebody as a consumer, fantastic, but you also need to protect someone's data because it's their property and they've created it themselves. So there's also an opportunity for the data trust to look like a different kind of vehicle where it's more kind of custodianship of a property. Maybe, I mean, I'm not the expert in that. That's why I leave it to you guys. But if we're talking about what digital identity solutions look like, I'm sorry to say this, it's not going to be legislators and regulators that decide it. It's going to be technologists. And so that's why I think pushing forward with the personal data trust license, you'll start to see some of the best in the world in terms of technologists and entrepreneurs lining up to apply for that and to build their business in Wyoming. And then we'll see who's the best business model, who builds something that is mostly unbreakable and unhackable. That's going to be where we start to get more of our definitions of how we protect digital identity and what that should look like. So, thank you for listening.
Yep, go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. With the Equifax hack, do you have a sense of who regulated them or what they actually had as a regulating authority from the security standpoint that would or would not say, hey, you're not up to date? It doesn't seem like clearly there was enough. We know that based on the number of lapses. Mm-hmm. But should someone have caught them, or is there just not really anybody that should have been looking?
Well, there's no legal requirement for them to be regulated by any particular body. So every company that holds data, whether it's a specific data company or any company that just has a database of their customers, they are self-regulating. If you choose to abide by no security or all security, nobody is really watching over you. And that's the major problem, and why I think having a regulated body, obviously under the division of banking or elsewhere, is the way forward, and it's going to instill the type of trust to make it a successful business model.
All right, Mr. Chairman, a different line of questions.
Yep, go ahead.
With regard to the consumer protection versus property right concept and the idea that they're not necessarily mutually exclusive, there's quite, I guess it's a challenge to draw the bright line between this data is my property because it's my data that I've generated about me versus third-party data that's actually generated about you. And do you know of any model that tries to draw that bright line or make it clearer that all right, this is something where consumer protection probably should be applying to the data, that concept, versus this is data that I own? Are there any efforts to draw that line? It seems like most are trying to go with one model or the other when regrettably it seems more complicated.
Right. So I advise quite a few blockchain companies at the moment that have sought and proven to be able to solve some of those problems. So there's certain data that you can keep to yourself or choose to monetize, and then there's certain data that you have only created because it's through a platform, and that platform deserves to own some of the value of that data creation. So you can either receive a dividend or an ongoing percentage of the value of that data that is monetized by that platform. And I could give you tons of examples of those companies. But Chris Land and I were actually talking specifically about if we're going to look at data definition as a property, we're going to have to make very sure that we're talking about what data you could say is personally identifiable and that you'd be able to claim as your property, and whether there's going to be any retroactivity on that, but also how you would define and regulate fractionalized ownership over data rights from data that you're producing, but is actually being produced by a platform that you're engaging with. So that's, again, a technology solution that needs to be complemented with laws, in my opinion.
Mr. Chairman, yeah, and I appreciate the fact that it clearly is very complex with fractionalization. Anything from a temporal standpoint where you're almost leasing data or something along those lines, same type of concepts being included?
And it's a concept similar to, again, Equifax or Experian or Axiom, any of the big data vendors these days. You could technically, through the ideas of most digital identity and data sovereignty solutions these days, you would be your own data bank, where you would perhaps even have an app that connected to a third-party personal data trust, and you'd be able to verify and connect and use APIs to send your data to other platforms, but other platforms would not actually physically possess your data in their own databases ever. They would only get access to the data points that they required in order to do the work that they needed to do, which would be very helpful for KYC AML purposes.
One more question, Mr. Chairman. And Ms. Kaiser, you may not know this, but I was wondering, based on that, do you know if under California's GDPR, if I were in California, if I could require that Equifax delete all of its information about me?
That's going to be interesting, and it's one of the reasons why they're considering pushing the implementation of that law from January 2020 back 6 months, because the right to delete these days is nearly impossible because of how many places your data has gotten to by the licensing and selling of your data, both on legitimate and on black markets all around the world. So what does a deletion really mean when your data really is everywhere and is easy to obtain? Also, the right to delete is a big debate in the blockchain community right now, because it's very difficult in almost every blockchain technology that I know of to delete data. That's one of the points. So I like to talk about, instead of the right to delete, the right to have transparency and consent onto access. So even if the data isn't deleted, you might say no one can ever access these data points again because I choose to keep those private, and that should be your choice. I'm not a privacy advocate, but if you want to keep certain data points private, you should have the right to do so, and you should be able to have full transparency over all of the data you're sharing and choose whether you keep it private or whether you want to share it, and then be able to share in the value of that monetization if you so choose.
Mr. Chairman, follow up on that. A couple of points. Well, first of all, we've got the test case of the EU, so I'm curious. They've got credit agencies, and I guess I don't know what happens when you're in the EU and you request deletion of your credit history. Maybe somebody does know, maybe you know. Do you have any sense of what happens there?
I actually haven't heard a case being brought on that yet. I'm sure there probably are. I'm very happy to fish around and bring that information back to you separately and also publicly in the next meeting if you'd like.
That'd be great. And then the second question is with regard to blockchain. If you have a public blockchain and you can imagine embedding a JPEG into the public blockchain, there really isn't even any way to close down access to that in the future. a public blockchain. So I was wondering if you had any sense of how something like that would be handled in the EU, where I can embed that JPEG into an immutable public ledger, and who am I going to, or whom am I going to request deletion of for that JPEG? I don't know if that's been an occurrence. Do you have a sense of that?
Oh yeah, all of the biggest blockchain companies in the world are spending millions of dollars with lawyers trying to figure out that problem because of the lack of the ability to delete on most blockchain platforms. Again, why I'm not the biggest proponent of GDPR, nor trying to copy it here. There are some great parts about GDPR, but then there are some learnings that everyone has had since May 25th of last year when it came into enactment, where we've realized, it's good that they decided to put something forward, but it's going to need really serious amendments in order to do all of the things that the legislators originally hoped.
Great, thank you.
Any further questions for Ms. Kaiser? Seeing none, thank you for joining us once again. And you're Wyomingite, right?
I am, as of June.
Congrats.
Proud to be here. Thank you, guys.
Welcome.
You moved here because of the blockchain bills, right? Yeah. Perfect. Any further testimony? Yep. I think I had Emma first, or Ms. Channing, sorry. Bob, you got to go second. Sorry. Yep. Ms. Channing, go ahead.
Oh, there we go. Yeah, it was off.
A lot more on now.
Yeah.
It is entirely possible to build blockchain-based DIDs that are GDPR compliant. Consensus has. In terms of the question that you asked with regard to who is investigating breaches and this kind of thing, well, that is actually something the GDPR requires now, is regular audits by national authorities, and that has in the last year seen several fines and audits successfully completed across the whole of the EU. And I think that demonstrates the need for that kind of watchdog. The third thing, and this is the thought piece of someone else within Consensus, but I would think extremely carefully about ownership of data, because there is, in a number of cases, particularly with regard to healthcare data, a very dangerous path to go down in terms of ownership. As in, your genetic data, your healthcare data, that is actually something you should never be able to sell or give away ownership of. That should belong to you regardless. And so I would caution the committee that there are many, many pitfalls and support Mr. Land's testimony. And I am sure both the Brooklyn Project and Consensus would be very happy to contribute to such discussions, help in any way.
Yep, go ahead, Mr. Co-Chairman.
Thanks, Mr. Chairman. I'll just note that we did pass legislation last year. We originally passed it a couple of years ago, but we had a little error in it on genetic information privacy. But we didn't go into data ownership specifically. We just laid out a bunch of thou shalts to basically protect that information, and kind of dodged the who owns the data concept since it was a bigger issue than the legislation was. But it is certainly something that I agree. There's some data that, boy, if it starts being sold and traded as a commodity, it's just a lot dodgier than other data, and genetic information is certainly among those. And I can only imagine at some point pointing and clicking accidentally on an end user license agreement that forfeits my genetic information and data to some company that's then irretrievable unless I want to buy it back. It's like there was I saw an end user license agreement about 20 years ago where clicking it acknowledged that you were transferring your soul to the corporation that programmed it, as a little bit of a joke, and it was in there, but I feel like maybe we're getting there again.
Ms. Channing?
Chairman Rothfuss, there are companies that have in fact sold that kind of genetic information, and I think also there is a very worrying trend amongst law enforcement. I think probably with the best of intent, but using open databases with very, very poor math to track down suspects. And I think that's a very, very worrying trend, both from the privacy invasion, and it's been used within an edge case, but like you can see how that edge case can creep back from horrific murder to goodness knows what. And the math's really poor. The math is not nearly as simple as anyone is reporting.
Further comments or questions for Ms. Channing? Seeing none. Thank you very much, Ms. Channing. Yep, Bob, you're up next. You got to wait past Bob. We've been ignoring him for too long.
And rightfully so. Bob Cornish, Anderson Kill. Brittany raised some very good points about the regulation of these data reporting agencies. While she was speaking, I took the liberty of pulling up the last 10 annual report that Equifax filed with the SEC before the data breach was released. In its prospectus, annual report to shareholders and obviously filed with federal authorities, Equifax claims that it is regulated by the Consumer Financial Protection Board and is also subject to punitive action by state attorney generals and others in the Justice Department under Title 10 of the Dodd-Frank Act, and that it arguably, we don't know what this means, but it states that it regularly cooperates with the Consumer Financial Protection Board's supervisory examinations, and mentions the fact that at the time, as of this last report, which I believe was 16, the Consumer Financial Protection Board at that time announced 35 enforcement actions imposing over $300 million of civil penalties, ordering $34 million of restitution. This is in a document that investors are supposed to be reviewing in terms of assessing risk. This is out there in the public. What I find interesting about this is that the attorneys who drafted this did not mention whether any entity such as Equifax had ever been subject of an enforcement action or were the subject of an action. There is the usual slushy language that says they may be, and that these things do not have a material effect on the company. Where I'm going with this is, again, Wyoming has a great opportunity to be a leader in this space in the absence of any federal leadership or federal wherewithal, really, to regulate and protect consumers.
Questions or comments for Mr. Cornish? Being that, I also got to apologize yesterday. Some of my colleagues were actually calling you Mr. Corning, and so I apologize on their behalf.
Oh, I've been called worse.
In their defense, I did tell them your last name was Corning to get them to do it. So,
but it was still
it was funny.
You could have had that joke going for 2 days.
Well, yeah. I got Miss Kaiser first, and then we'll go back to Division of Banking.
Thank you, Mr. Chairman, members of the task force. I just wanted to quickly respond to some of Ms. Channing's comments, which are incredibly important, and I'm very glad that she raised them. So firstly, talking about owning your data as your property, I would never suggest that that was a transferable property right. You would always own the data that you produce. It just depends on whether you want to license access to it. So that's an important point if we're talking about legislative frameworks. Also, when we're talking about whether or not you are interested in licensing out your data, again, it's a personal choice. If you want to keep your data private, you can continue to keep your private property private to yourself. But you know, if you think of it like how sexual empowerment campaigners talk about owning their body, your data that you're producing could be an extension of your body. So you're not going to transfer that to anyone unless you want to. That's a consent-based conversation, right? But if you are talking about whether or not you want to share data or keep it private, a lot of people that campaign for privacy, it's because it's based on the idea that if you share your data, something bad is going to happen. That you cannot share your data securely, that you cannot share it with people who are intending to use your data for good. And I think that's a very dangerous assumption to make. One of the main reasons why women and minorities do not have medicines work as well on them is because the only medical data that is available are young white men, 18 to 35 years old, that go to medical trials in college for extra money. That is a disaster. It's a human rights disaster everywhere in the world. So the idea that you would be able to own your healthcare data and easily share it with medical researchers around the world, medicines are going to start working for people like me, and we're probably not going to have cancer or diabetes for that much longer. So I don't want the scaremongering word of privacy to hinder the idea that data ownership as a property, whether it be your healthcare data or your financial data or your education data, to throw anybody off wanting to do this. Thank you.
Questions for Ms. Kaiser? Seeing none, thank you very much.
Thank you.
Division of Banking, Commissioner Forkner.
There we go. Thank you. Again, just want to follow up on a few things. I want to be a dead horse, but I want to make it clarify a few points. And so one thing that regarding Equifax and the issues there, I know we're talking much broader, but in January or June of 2018, 8 state financial regulators entered into a consent agreement with Equifax as a result of a multi-state examination that was California, New York, North Carolina, Texas, and a few other states. And so there was a review of it. Equifax does, depending on the state's laws, and I think they fall under Wyoming's as well, as a third-party service provider for financial institutions, because there is that link between the information that's being sent to repositories like that. Now, that being said, we don't have the bandwidth in our office at all to tackle a company like Equifax. In fact, as you could tell, the states that were listed there are larger states with a big shop, but there is authority under banking laws as a third party and under federal law. We're actually working on a proposed amendment to make it clearer between the federal agencies and the states what that can be shared. We do, the large core providers of banks get examined regularly, these large companies, by all of the federal agencies and states on an annual interagency basis. So they are subject to that. And also, what was mentioned earlier, that I think everyone saw the news that the CFPB, the Consumer Financial Protection Bureau, and the FTC, as long as 48 states, entered into a settlement agreement with Equifax to provide up to $700 million in restitution and fines. The proposed settlement with the Bureau, if approved with the court, will provide $425 million in monetary relief to consumers, $100 million in civil money penalties and other relief. Now, to Ms. Kaiser's comments that, yeah, some of the consumer protections is on the back end, right? The breach already occurred. But now, I think what I identified that there was a hole on how do the states and financial regulators as a whole regulate this type of entity. What's the role there? Again, a core service provider for a bank that's directly tied into the institution that their accounting platform is based on is different than a third-party repository, a third-party vendor. There's third-party vendor management requirements, things of that nature. But it did highlight that, well, wait a minute, we got to look at this a little bit more. Did want to note, though, that there is at least a start and a recognition in the financial services space of entities like that, recognizing, again, this is a much broader discussion than just Equifax and like companies.
Questions for the Division of Banking? Go ahead, Mr. Land.
Thank you, Mr. Chairman. Senator Rothfuss, you had a question earlier about the GDPR and whether they could require Equifax to delete their credit information. They can't. There are a number of exceptions to the GDPR. First is freedom of expression. The second is any law that a member state of the EU passes declaring retention of the data to be in the public interest. So I think credit reporting would obviously fall under the public interest. there's a public health and a statistical research exception too. So,
Further questions? Seeing none. Further public testimony? Any other public testimony? All right, we're closing public testimony. Committee, is there any pleasure? No? Anybody want to move forward with a piece of legislation? Seeing nothing. All right, we're going to close that topic out. For the committee and the public, we're going to go to lunch until 1:30. We are woefully behind, so it's going to be a little bit of a longer afternoon. We still got to catch up to play from yesterday in regards to digital identification. Representative Yin, who was in Canada, I'll remind you of that, could not join us yesterday due to Canada. So we're gonna cover that this afternoon. Also, we'll probably have that towards the end of the day. Somebody's got to pick on them. All right. With that, we're at break until 1:30.